Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agenda's a disguise. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Are you guys ready for the grand finale? We have reached the home stretch of the Cardi B trial that no one knew they needed. Okay, y'all didn't know you guys needed to watch this trial. Huh? Most of y'all didn't even know it was going to happen. But we've been over here discussing this trial and we are at the home stretch. So now what is going to happen is there's more jury instructions to give to the jurors before they deliberate. But before they deliberate, they have closing arguments. So we'll see if Miss Ellis can tie this thing all together or if Miss Cardi B gets another W under her belt. So let's see. I'm just as anxious as you are. So in closing, they're going to talk about what the evidence showed. If they did not show the evidence, that is also something to bring up that they weren't able to show and prove what they said they were going to prove. Y'all said you ready. I didn't even introduce myself. To those of you that don't know me, I think all of you all know me. But my name is Pam Esquire, also known as the Law Intellect. Thank you so much for joining me. Thank you so much for all of the new subscribers. And also, thank you for liking the video without me begging and pleading for you to do so, because I know you already did that, all right? So right now, we are waiting for them to get this party started, all right? Because we have to see how this thing all goes. We got to see. Hopefully, Miss Ellis's lawyer spent this good holiday weekend looking at a few critiques and making sure that they bring it the way it should be brought. Okay? That's what we hope. All right. So right now we're gonna wait and see what Law and Crime got going on. I mean, not Law and Crime, Court TV. If not, we'll go to Law and Crime. But that's where we at, y'all. I hope you guys had a good holiday weekend. Hey, Vonnie. Hey, Sunshine, Symmetry, Patty, all of you guys. Thank you guys so much for coming over here and kicking it with your girl. All right. So let's see. We just waiting patiently. We just waiting patiently. So Miss Ellis is gonna have to go first. And then Cardi's attorney will go next. And then depending on the judge, see, for me, when I've had a situation as the plaintiff of which the judge was like, you get an hour on your closing and you get 15 minutes on you because you know get the last word because it's my burden. And I always get it taken away because I talk too much. But in theory, you should get the last word as the plaintiff. So we'll see how this goes, y'all. We'll see how this goes. Well, yeah, I get all passionate and then I sit down, and usually if I have a co-counsel or like somebody with me, they're like, girl, they said an hour. You've been up there for an hour and 30 minutes. I'm like, what? I didn't know that. So I probably should have a timer, a watch or something, but I don't. I just get up there and start flowing, start getting into it. You know what I'm saying? Because I believe in my cases. I believe in all of my cases that I am a part of. And then I start talking too much. So hopefully, Miss Ellis, his attorney, has a little bit more cohesiveness and coherentness in this closing. What was one of the biggest critiques of this was the questioning was all over the place. It didn't seem like a method to the madness. And so hopefully he takes this opportunity to tie this all together, because this is the last shot to help your client. Now I wonder what
necessary to protect
Miss
it.
Ellis is
So,
thinking.
how is the jury supposed to understand what that means in the sense that she's engaging, is it only the right amount of outrageous conduct or only the right amount of intent to cause extreme emotional distress?
They must be going over
Well, first of all,
instructions.
so those two points, 1 and 2, are taken directly from the case instruction of self-defense. And
Correct.
so the point here is that if the jury is going to find that Ms. Almanzar acted in self-defense, then allowing a claim to be stated by pleading it as intentional infliction of emotional distress would be an end run around the fact that she was acting in self-defense.
All right, Mr. Here.
Yes, Your Honor, I agree with the court that it is confusing, and I would ask that this will not be submitted.
All right, I'm going to refuse special instruction number 5. All right, and then 3903, we just corrected that.
Yes, that's correct.
All right, that's how I gave it, and so I'll just swap that in. I'm not going to give it again.
So right now, this is outside the presence of the jury, and they're going over issues with jury
It
instructions.
basically says medical expenses past and future.
I think that is the proposed instruction.
You know
I
what?
recall theirs to be a little bit different.
Your Honor, it looks like he's combined 3903 with 3903A,
Oh,
which is the next page in my binder that was given.
I wish they would have it that way. Because I do think it's confusing. But since I've already given it, I'll just swap in 3903 and 3903A as already read. Because I did already read these.
So I'm sorry, you're going to keep the one that's been read already, is that what we're saying?
I did give these jury instructions, I gave them as
It's
the.
not going to be very
It's
exciting,
without
okay?
the.
Giving you the
I
warning.
think the proposed instructions had language that I struck out, so this is just a clean.
Okay, the one that I submitted this morning is directly out of Casey.
But you combine 3903 and 3903A. And that's not how I gave it. So if it had been given to me that way originally, I would have read it that way, but I didn't, so I don't want to change what I've already read. All right, 3905A. Did I already give, I think I already gave a version of that as well, right? Or maybe I didn't.
I'm not sure, Your Honor, you asked that we just include the case instruction rather than a special instruction. So this is just the case instruction.
Okay, so I will give that.
Your Honor, I also submitted a 3905
Is that straight from the cases?
straight from the Casey.
Okay,
Are they
they're the same.
they're the same?
Correct. All right, 3934. That was not in the original package.
That was in the original package.
It
Your Honor.
was.
It was modified only because now that the damages are more limited than what Mr. Rosenthal was proposing earlier, we've just changed the last sentence.
Oh, okay. And I did not read that on Wednesday. Is that correct?
I don't believe you did.
Correct.
Okay, so I'll give 3934. Special instruction number 8.
Special instruction number 8, there are just two differences from the Casey instruction. The first is that punitive damages cannot be awarded if there was accidental harm. The second is to include that's paragraph 3. Paragraph 4 is to include provocation as part of the jury's consideration of punitive damages. And we've identified a lot of supporting authorities in the notice that we filed with it. And I believe even Wittgen states that it's proper to instruct the jury on provocation when they're considering punitive damages.
Yes, Your Honor. My understanding was the trial would be bifurcated, and we would only get to this point after the jury made its decision as to the first non-punitive damages stage.
Well, this is a modification of the casing that is given during the first phase. So do you want to be heard on the modification, specifically accidental or heat of passion?
Again, Your Honor, I don't really see a need for this one because there is a specific KC on punitive damages that can be read.
I understand that. He is suggesting that it be appropriate to amend the KC to add accidental harm and heat of passion. Do you want to be heard on that?
Yes, Your Honor. So my point is that none of the cases should be changed. And this is an example of one that's really so far off and completely different than what the KC states. Position.
All right, submitted.
Yes.
All right, I think special instruction number 8 is appropriate, so I'll give that. Special instruction number 9 is going to apply until we get to punitives. All right, let's go through plaintiff's proposed instructions.
No, there's one more I need to add, 3932, life expectancy. I have it here.
Is it printed out?
Yes.
And is the math right?
May not be. I'm willing to reduce it if that's the case, but I believe it's close to the number. Oftentimes, we'll have a stipulation with counsel, so if they want to reduce it to 40 years, I'm fine with that. I just picked a close enough number.
So what evidence do you have that she will continue to have future? I guess she testified that it still bothers her, is that?
Yes.
Okay. Any objection to 3932?
Yes, Your Honor. I'm not sure that she testified that it still bothers her, but in any event, first of all, this was never shown to me. We're not sure that the math is correct, and this is just not an appropriate. This is not an appropriate instruction in a case like this where it's
So,
over an alleged scratch and there's a overwhelming amount of evidence that it wasn't caused by it.
didn't she try to say though
Go ahead.
So I'm
that it
confident
already
that
was
if it
recovered,
was changed to
basically?
40 years, it would fall well below the threshold of the national violence statistics.
That's why she
report.
didn't put it in her medical records or her
So I'm
psychological
willing to do
records
that.
because
If
there was
it's a
no
different
fee.
number that they propose, I'm fine, but there should be some kind of KC 3932 of life expectancy so that the jury can understand that.
So she wants future damages too, up to 40 years for her
Where's
life.
that chart in the cases? Oh, here it is. And she's 32 today?
Yes, she's 32 years old. Yes, she is.
It appears to be correct. This is 50.3 and they've got 50. All right, I'll give 3932 over.
He
plaintiff's
tried
defendant's
to
objection.
save his case by saying that the reason why it wasn't in the
All right,
medical record
plaintiff proposed 3901.
But
I
the
think that is
psychiatrist-
3901.
because it wasn't bothering her anymore.
That's not correct.
I don't know. I guess. I know I'm talking over the whole entire video, but So what I was saying is watching the testimony, I believe, and again, this is very vague. I've probably looked at 30 cases since this one. But there was some testimony where he was trying to elicit that what if she was from the, I think from the psychiatrist, why would she, if she's already been healed from it or whatnot, why would she mention it when she goes to the doctors and in medical records and all of that? That was part of what he was trying to elicit from that doctor. So all they got to do is use that to show that it's no future. And what future do you have for you psychologically? I, I don't know. I don't know what future the damages she's alleging for this scratch. I don't know.
Well,
It's in the binder.
the one that I did, Your Honor, is from the case, which seems. to
Oh,
have
the
a lot more
scar?
evidence than Theirs.
That can't nobody see. Nobody's
Yeah, I already
taking the
did give
stand.
three.
The case is over. Everybody rested.
So you're
It's
gonna
half
go with that
the
version?
argument.
It's straight from the casing. 3905, I think I already gave.
May I be heard on that, Your Honor?
Go ahead.
So the one that I've submitted today has all of the different types of physical pain, mental suffering, and emotional distress. Their version doesn't really cover everything at all. It just has a small amount.
Yeah, I don't think it's going to take long for them
It's
to
missing
deliberate it.
an entire paragraph, at least a portion of it. So I would request that plaintiff's version be read to.
All right,
What
I
treatment
just
does
looked, I
she
did not give 3905 on Wednesday. And plaintiff's is straight from the casing,
Yes, sir.
and defendant had a different
I
one.
guess.
I think theirs is 3905A, so maybe that's why. But I would like 3905.
Your Honor, I believe the difference is that 3905 and 3905A, we just submitted them as separate instructions, and plaintiff's counsel has combined them.
Your Honor, I don't think I've combined them, but
Oh, I see. The defense proposed version does not define,
doesn't cover.
yeah, it's not the full instruction, so I'll give plaintiff's proposed instruction. All right, 1600.
Oh my gosh. How many issues
I
did
think I gave 1600, didn't I?
I believe you did.
I thought the court wanted us to work on the 1600s, but I may be mistaken.
Your Honor, it was the 1602 instruction, which was the special instruction 4 we discussed earlier.
I did give 1600 already.
I have a copy of that class in the 1600s.
Okay. Did we give a version of that?
1602 is the special instruction 4 that we discussed a few minutes ago.
And that, okay,
And
so I'll give the modified version.
thank you.
1603, did we give that?
No.
1603 was included in ours as well. I believe the court asked that we include it, so
Okay.
that's in our book.
And 1604,
I believe was given.
was already given. All right, tell me we have an agreed upon verdict form.
Unfortunately, we do not, Your Honor.
Can you highlight the differences?
Well, yes, Your Honor. So I've never seen it the way that they proposed it, with the preponderance of the evidence language. It's also something that they just created as a form that doesn't really reflect any type of special verdict that's really I've seen in any case before. I'm not sure what that is. So the one that I've done, Your Honor, I've done two different ones. The distinctions of the two that I've submitted is page 7 is added with respect to punitive damages. And the other version does not have the punitive damages. Question number 19. That is the only distinction between the two versions that I've filed with the court. And I did give a courtesy copy to the counsel. It was filed today at 12:19 a.m. with two different verdict forms. I did submit it to the court this morning without the caption of the attorneys.
Sherman.
Just so it would be somewhat of a neutral form. And I request that one of these be used because the one that they've provided doesn't really follow the usual method. I don't think it even has a signature line.
So she claimed emotional issues, but I heard depression. I heard maybe symptomology from PTSD, but I'm assuming maybe she did because remember, Cardi's attorney, they had an expert who elicited or gave testimony that according to their analysis of her, when they examined her, they were saying that it didn't match because she went out places, she went out of town, she went on trips. Like PTSD has different symptomologies. Now she is saying emotional distress. So I don't know if they're trying to say that fits into it, but yeah, she is, generally speaking, she is alleging some type of emotional issues that stemmed from this alleged altercation with Cardi B.
Form as much as possible. I believe it even has fewer questions than the plaintiff's form. And that was after our discussion that the previous form was complicated, which we agreed. We believe this is clear cut. It includes all the issues. It should not be difficult for the jury to understand or to answer.
That's what they said.
Go ahead.
So the worst part of it is it again states by preponderance of the evidence. That's not usually in a special verdict form. They put that throughout the questions, kind of limiting, kind of creating a way for the jury to think ahead of time. It just doesn't make sense to have that there.
If you're just coming in, this is the boring part, but thank you all for sticking with us. We just don't want to miss whenever the fireworks happen. But they are going over the jury instructions. Each side, they submit their own proposed jury instructions. Oftentimes, you have the standard jury instructions that'll give you the elements that need to be proven. But in certain situations, you may need special jury instructions that aren't covered by the standard jury instructions because of the uniqueness of whatever is going on in the case. So sometimes what you will do is you'll get case law to support it and you create a jury instruction and you see if the judge will allow it. And then there may be jury instructions that are standard, of which both sides don't agree that the jury should consider what's in those instructions. So when you have the proposed jury instructions from both sides, there's always typically there's some disputes on which one should go back to the jury. So this is what they are debating now. Of course, ultimately the judge makes the decision. They've already made some decisions of which they said that it will be confusing for the jury, so they didn't allow the special jury instruction. So that is what is happening now, and that is what a special jury instruction is. So I know when I do auto accidents, I usually have a few of them, especially if someone has been in prior accidents, slip and falls, or anything that may be that the other side may point to being the cause of an injury that I'm saying was caused by an accident. So there's a special jury instruction that I typically use that is contingent on a case, of which basically it says if you can't decide where the injury came from, then you have to decide that it came from this accident. Like if you believe it could be multiple places, then you have to decide from this. So you may have it where pre-existing injuries, there are different instructions specially that you need to give that corresponds to your case. And so that's what they are going over now. Apparently the case is bifurcated, so they want punitive damages. However, they won't consider punitive damages. In this case, it will be a separate bifurcated hearing, and it's probably just contingent on if the judge doesn't give them a no cause, because if they give them a no cause, they ain't getting nothing anyway, let alone punitive damages. So that is what's going on now, for those of you that were wondering why we're listening to all this boring conversation. After this, there will be more than likely the closing arguments from both sides, from the plaintiff and the defense. And then the jury instructions will be read, and then they will get up out of there and they will deliberate.
For any verdict form is done. So I have a printer with me today. I can make changes. I can email it to the court if the court wants to do something with it. Their form doesn't cover any of these questions for any of them. Either it's all or nothing, and that's not how a special verdict form reads. So I would ask that the court allow.
I'm just inclined to do a general verdict at this point in time.
I'm willing to accept that, if that's what the court wishes to do, but theirs is really off base, and it does not cover.
They also give proposed.
Your Honor, there's multiple.
They also give proposed jury verdict forms, which is if you believe that Cardi B scratched Miss Ellis in an altercation, intentionally harmed, all of the elements of battery, check this box. If you check yes, go to the next question. If you check no, then you're done. So they have verdict forms as well, where some want lengthy verdict forms, some want short verdict forms, but you also argue over that. We argue over everything, okay? We argue over everything and try to get whatever we can that seems more favorable and beneficial to our client. So that's what they're going over now. If you are new here and you haven't been here, and some of you I haven't seen in this chat, please make sure you're respectful. You can have different opinions, but nobody is smarter than the next person. So if I feel like you're degrading anyone in my chat, you will be blocked, not timed out, but totally gone off in the abyss, where you'll be listening to us and not being able to comment, because apparently you don't know how to play on the playground in the sandbox with other people. So that means you got to go to the principal's office and stay in there with the door closed. Okay. You know how it feels, because if you're in here bullying, you probably was doing the same thing when you was a kid. So you should be used to this type of consequence, to this type of behavior. Thank you so much.
Just for negligence?
No, not if it's violence.
Not if it's what?
No, we don't believe you can.
Okay, so, but you do have a punitive damages question linked to question number 9, which is damages for negligence and comparative.
We can strike out the end of that of 12.
Thank you so much,
Question
Legally Bomb. I appreciate it.
Yeah.
Here's what I want to do. I think the defense version of the verdict form is, for all intents and purposes, a general verdict on each cause of action. I think it's straightforward. I don't think it's confusing. And so the only remaining issue that I have with it is that you've got damages for each section, whereas there's a jury verdict that says that they only decide damages once. So how do we deal with that?
So We did it, we did the form this way
Yeah.
just to avoid having to ask
I
questions
don't know if
like,
she
did you
filed the
answer
claim.
question this,
No, no,
question
no.
that? However, if you look at question 7,
So I believe the accidents did happen after the incident, from my understanding. I believe it might have been 21 or 12. They didn't really get too much into the accident. However, the lawsuit was filed in 2020. So that's why couldn't just generally say yes or no about your question. So if you're by claim, you mean lawsuit, that was filed in 2020. The accidents were around about that time, but it was after the incident with Cardi B, which allegedly occurred in 2018. That's where I got 18 from. I said, why is 2018 stuck in my head when I was going over the Shirley Strawberry Nesto situation? And I thought they got married in 2018, but I think I got that from this Cardi case. See, work with me, y'all. Work with me.
Limited to the scratch and nothing more. That the scratch itself did not cause past or future, maybe isn't going to cause future emotional distress, but they find that the intentional infliction of emotional distress was more longer lasting.
For example, Your Honor, have you heard?
Go ahead.
For example, they may find that there was an assault and battery and no intentional infliction of emotional distress. By removing the damages section, they would never be able to award any damages. So that's why I request that it at least be left there so that they could give damages to the parts that they wish to give. And counsel on both sides can argue duplication, don't give it twice, break it down.
Your Honor, that would be incredibly complicated, difficult to separate. It wouldn't work. I understand your position, but there needs to be some way of ensuring that there's not duplicative damages at work.
Your Honor, they have multiple attorneys on their end. They've created this form. If the court is going to go along with their form, then they should have to live with the form that they created.
The form that we've created does not have that risk of duplicative damages. I'm sorry. The other thing is that I think we've already established with the jury instructions that there are not damages that are awardable under some causes of action but not others.
May I add one more thing, Your Honor?
Go ahead.
Yeah, I'm sure the court has seen it in many cases where it is broken down. There's the damages award specifically for one cause of action, like in this case, assault and battery, and another one for intentional infliction of emotional distress. In closing argument, counsel obviously can argue how this form should be filled out, and as confusing it is to me, I'll have to just live with it. To take away the damages section in assault and battery would mean that it's too confusing. It should be separate so that the jury can decide whether there should be any damages for assault and battery and any damages for any other cause of action.
Your Honor, we could, in theory, have one question for the damages and just not duplicate them. And that the only difference there would be we would have questions like, did you answer yes to the question 3? Did you answer yes? Like what we did with the punitive damages. That would be one more difference.
How about we modify question 7? What are Ms. Ellis's damages? If you answer question 4, only include additional damages for this cause of action.
Can we include if any, Your Honor?
If any.
So So again, it is very confusing because assault and battery is a separate cause of action and has its own damages component. By leaving the form as is, the jury can then decide if they're going to give any damages for assault and battery.
They can, it's under question 4.
Right, in 4. And then they can do it again for 7. They can do it again for 9. They might not do it in any of them. So that way they're able to break it down and decide what, if any, damages they're going to be awarded. Each cause of action has its own damages award.
But you can't double count.
I'm sorry, Aaron?
You can't double count though.
Double count, what does that mean?
Meaning include the same emotional distress that if they find that she has a certain amount of emotional distress, are you asking them to allocate it between the different causes of action or just?
No. I'm just straight asking assault and battery. This is what it is. If you find that an assault and battery, it should really be separate. Now, let's say we
Yeah, it's normal, Sabrina.
Was there an assault and battery? And then what are the damages for assault and battery? It's really harmful to have it assault and battery combined because the swing that was taken was the assault and the cut to the face was the battery. So we're then limited to one damages in number 4. We're limited to one set of damages for both assault and battery. So then in my closing, I have to explain that. Same thing, intentional infliction of emotional distress, separate cause of action, it has its own damages. Negligence has its own damages.
Your Honor, I believe that, first of all, the addition that you proposed would address that. Not including something or just including more damages questions would.
They bored me. Okay, so you said yes, this is normal to a degree. Sometimes it's not as contentious. Usually doesn't, in my experience, it doesn't take too long. I don't know how long this is gonna take. Tyrone asked Pam what bar association is the lawyer with. He is licensed in California, so I assume he is a part of the California bar. But if you're talking about, some people are also a part of like the American Bar Association, is of course the general one that most people are a part of and where a lot of our rules derive from. It's from the American Bar Association. My son said Cardi about to be 2-2 in these cases. She shouldn't get nothing. She's making Black women look bad. Yes, he is a good lawyer too. Keisha J says she shouldn't get nothing. She's making Black women look bad. She ain't making me look bad. She's making herself look bad. And he is a good lawyer. So I'm assuming you're talking about her lawyer. You're talking about Miss Ellis's lawyer. He may be a good lawyer. That's why I said he may have just had a little fumble over here. Again, maybe he thought the case was going to settle. He has experience. Like, he's been doing this for some years. Now, I'm not saying experience equates to being wonderful in the courtroom. But what I am saying is he ain't new to this. Okay, so perhaps he did have, I just say the questioning seemed all over the place and ill prepared, in my opinion. It doesn't seem like he had the cohesiveness for everyone to follow. I think the jurors asked questions we all wanted to know, which means that it was probably questions of which you probably should have asked as well. So yeah, there's a lot of critiques with her lawyer. Cardi B lawyers are decent. You know, the woman that did, I think she may have crossed one time. She, I think, was a part of the defamation case with Tasha K. And I think she had some other lawyers originally, and these are newer lawyers that were on there or whatnot. I don't know. So yeah, I think Cardi B was the epitome of what a witness should be. She was likable. She was herself. She didn't try to change it up. She was very matter of fact about what happened. She never swayed on what happened. She talked about this 5 years ago when the lawsuit was first filed, and she maintained. And then I guess before that, the lady, I guess, came, Miss Ellis came on allegedly, I didn't see it, and talked about what allegedly happened. And she came on and said the girl was lying back then. I think that she did very well on the stand. And if this is how she acts in court, then I can see why she out here winning. I think she's a believable witness. She cussed when she needed to cuss. She said what she said. She said she called her what she called her. You know, I mean, she threw a little kicks and giggles in there. And the lawyer opened up the door for her to say certain things, such as, you are you handicapped? Well, I was pregnant. I feel, yeah, we do be feeling handicapped. Same thing with him talking about her wigs and all of that. Like, you opened up the doors for her to shine in her personality, which is why people liked her. People like Cardi B for the realness and relatedness. That's why they liked Cardi B. And she did the same thing. That's what made her famous. And she just did the same thing in court. One of the issues we have with a lot of our clients or witnesses is they get on the stand. Of course, they feel comfortable with us because we're their attorney, but they don't know how to handle people throwing accusations at you or trying to elicit testimony that seems against who you are as a person and all of that, and not keep their cool. I think she kept her cool. She was a great witness. I'm just saying.
Go ahead.
My understanding under California law is that you can't take judicial notice of the truth of the contents of a website. And there is case law on point I could refer the court to.
Well, I'm not necessarily worried about that. I'm just worried about whether, I don't think that there was any representations of the date it was taken. She did just reference it generally, but the substance of the testimony was that she had those nails for the entire time that she was here. So whether it was taken on one day or a different day, I don't think that's material.
Can I respond?
Go ahead.
So, the purpose of this is really not to make anybody right or wrong. The purpose of judicial notice is just to clarify when the All-Star game took place. And the second half of it is when the photograph was taken. There's overwhelming evidence attached from different news outlets. There's
Again, is it material, the date? She said she had those nails for the entire week.
it's material, Your Honor, because the defendant testified that that's what she was wearing later in the day, exact same day. She had those nails. You have testimony all over the place about the fact that this photograph was taken on the same date of the All-Star game and the same date of the incident. What was the error there is that the All-Star game was on February 18th of 2018, and the court said that we didn't have credible evidence at that time about it, so that's why the judicial notice was prepared so that the court can see for itself that the All-Star game was on February 18th of 2018.
Okay, I'm gonna deny the request for judicial notice. All right, are we otherwise ready?
There's one more thing,
Go ahead.
The court asked that I prepare a statement regarding the death of John Sherritt.
Okay. You have that?
Yes, I do. I did give it to the court. It would say plaintiff testified that she treated with John Sherritt MD in relation to this case in 2018. It is undisputed that Dr. Sherritt died on March 5th, 2020.
After a lot of back and forth, what we agreed to, what I agreed to, was that the court could instruct the jury that it is undisputed that Dr. Sherritt died, period. This March 5th, 2021 date, it's not in evidence. Plaintiff didn't testify to that. She said she understood he died sometime in 2021. She also testified, and we launched the transcripts. I can cite to where in the transcript she says it. Page 148, lines 12 through 149, line 15. She says that she went to see a Dr. Sherritt, and he told her not to have any treatment. So this assertion that plaintiff testified that she treated with John Sharon is not supported by the evidence. It is, the March 5, 2021 date is not supported by the evidence. The only portion of this that is actually what I agreed to was it is undisputed that Dr. Sharon died, period.
Okay, you heard. So, but this is what I would propose reading. Plaintiff testified that she treated with John Scher, MD. Does not dispute that Dr. Scher has passed away.
Your Honor, she did not testify she treated with Dr. Sharon. She sought medical treatment. This is page 148, line 12 through 14. Around that time, unclear when that is, did you also seek medical treatment from Dr. John Scher? I did. And then at line 22, and when you saw him, did he advise you that you needed to wait at least 1 year? He did. So
Okay.
that goes on page 149.
So I will read. Plaintiff sought treatment with John Scher. It does not dispute that he's passed away.
Well, plaintiff testified she sought.
Very good.
Thank you, Your Honor.
What will we read, Your Honor?
Plaintiff testified that she sought treatment with John Scher, MD. It does not dispute that he has passed away.
Thank you, Your Honor.
Okay. Now are you ready?
Well, there's a couple things. In my closing argument, I need the verdict form. So I can't start
Understood.
without
We're working on that.
that in hand. The other thing I wanted to say, Your Honor, is Your Honor did allow me to argue and clarify the NBA All-Star game when it was, the photograph. I want to be very clear that I intend to argue that in a closing.
It's not in evidence. I think what you said was they didn't provide the date. And you're fine, you can argue that they didn't properly authenticate the photograph in terms of the date.
Your Honor, the court said that I could argue this in my closing,
You could argue it. You could argue that they didn't establish what the date was.
and also that the All-Star game was on February 18, 2018, the week before. Like, the week before the incident. I don't see the harm in that. They can object to that. They can say their version. But that's part of my closing, Your Honor. And this photograph, by the way, this photograph was sprung at the last minute. It was never produced in discovery.
Go ahead.
Just briefly, a couple of questions. First, as if you remember, counsel violated a motion in limine order. And now he's talking about arguing things that are not evidence, which is completely improper. I don't want to object every 5 minutes to his closing argument. I would ask that at least let me say, if the court doesn't want to tell him, that he has to follow the rules. He can't argue out things that aren't in evidence. He can't violate the motions in limine.
I think it's readily apparent that you can't argue facts that aren't in evidence. I think plaintiff's counsel knows that. I think he knows that he would be violating the rules of professional responsibility by intentionally arguing facts that are outside the evidence that was presented in court. If he wants to present that and you want to object, then that's how we'll proceed.
Thank you, Your Honor.
Need the same. Are you done?
Then two procedural questions. Does the second monitor work and can it be facing the jury so they can clearly see it?
I don't think so. But we're in the middle of a transition and I don't know.
Okay. And
We can see it's not.
Your Honor's preference, we have demonstratives and we have things we're going to show, intend to show. Do we need permission to publish admitted exhibits?
No.
And do we need permission to publish demonstratives? They have been provided to plaintiff's counsel.
No. And it's argument.
Yeah, okay. I just want to make sure. Thank you, Your Honor.
All right, anything else from plaintiff's counsel?
Yes, Your Honor. I feel that what counsel has just stated is really below the belt and disrespectful to my side. I would never argue things that are outside of the evidence.
I think you just said you were going to.
No, I didn't say I was going to. The court told me that I can argue the issue of the photograph, that it wasn't taken on the day.
Correct. Your position on Wednesday was that they didn't establish the right date. And you can make that argument.
That's exactly what I wanted to do.
Okay.
Thank you very much, Your Honor.
All right, are we ready to move to the jury?
I must have the verdict form before I start.
All right,
They're being printed right now.
let's bring it.
Lord have mercy. I'm trying to eat, you guys. Well, so now they should be getting into closing arguments. Jury is about to come in, but Miss Ellis's attorney says she needs the verdict form, so they're gonna have to type it up and print it out because he wants to use it in his closing argument. So now we gotta wait for the print for him to get started. But in the interim, make sure you grab your drinks and your snacks because I'm sure this is gonna be a long ride. We can tell by the fact that his attorney wanted to argue stuff that wasn't in the evidence, and then when the other side mentioned it and said, well, can I object, because it is pretty
Welcome back,
rude.
everyone. We're still on the record in the Ellis matter. We now have defendant with us as well as the members of our jury and our alternate. Based on the fact that you're all here, I'm assuming no one hit the lotto over the weekend. Folks, we thank you for your patience. We did have a few procedural issues that we needed to address prior to bringing you in. We are now ready to proceed with the last batch of jury instructions. I'll try to give context to these to the extent that it's necessary. I will put them into the package where they belong, but I do need to give these to you. And we're going to relieve the court reporter of her obligations to report these by stipulation of the parties. Okay, here we go. Words alone, however threatening, do not amount to an assault. Aggressive and threatening actions do not constitute an assault unless they were intended to cause immediate, harmful, or offensive contact. If you decide that Ms. Almanzar assaulted or battered Ms. Ellis, you should fine for Ms. Almanzar if you decide that Ms. Almanzar was acting in self-defense. To succeed, Ms. Almanzar must prove both of the following by a preponderance of evidence: that Ms. Almanzar reasonably believed that Ms. Ellis was going to harm her, and that Ms. Almanzar used only the amount of force that was reasonably necessary to protect herself. Ms. Almanzar claims that Ms. Ellis's own negligence caused or contributed to Ms. Ellis's claimed harm. To succeed on this claim, Ms. Almanzar must prove both of the following: that Ms. Ellis was negligent and that Ms. Ellis's negligence was a substantial factor in causing Ms. Ellis's harm. If Ms. Almanzar proves the above, Ms. Ellis's damages are reduced by your determination of the percentage of Ms. Ellis's responsibility. I will calculate the actual reduction. Ms. Ellis may only establish her claim for negligence if she proves that Ms. Almanzar engaged in negligent conduct that caused Ms. Ellis to suffer physical injuries. If Ms. Ellis can prove that Ms. Almanzar caused her to suffer only emotional injuries, and this is under the negligence cause of action, Ms. Ellis cannot establish her claim for negligence. Emotional distress includes suffering, anguish, fright, horror, nervousness, grief, anxiety, worry, shock, humiliation, or shame. Ms. Ellis claims that Ms. Almanzar assaulted her. To establish this claim, Ms. Ellis must prove all of the following: that Ms. Almanzar acted with the intent to cause harmful or offensive contact, that Ms. Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner, that Ms. Ellis did not consent to the conduct, that Ms. Ellis was harmed, and that Ms. Almanzar's conduct was a substantial factor in causing Ms. Ellis's harm. A touching is offensive if it offends a reasonable sense of personal dignity. Words alone do not amount to an assault. Outrageous conduct is so extreme that it goes beyond all possible bounds of decency. Conduct is outrageous if a reasonable person would regard the conduct as intolerable in a civilized society. Outrageous conduct does not include insults, threats, indignities, annoyances, hurt feelings, petty oppressions, bad manners, or other trivialities that a reasonable person is expected to endure. Outrageous conduct also does not extend to profanity, obscenity, or abusive language without circumstances of aggravation. In deciding whether defendant's conduct was outrageous, you may consider, among other factors, the following: whether defendant abused a position of authority or a relationship that gave her real or apparent power to affect plaintiff's interests, whether defendant knew that plaintiff was particularly vulnerable to emotional distress, and whether Ms. Almanzar knew that her conduct would likely result in harm due to mental distress. Under factor A, which is the position of authority, examples of positions of authority or relationships of power include an employer to his employee, an insurer to its insured, a landlord to his or her tenant, a hospital to its patients, an attorney to his or her client, or a religious institution to its members. Ms. Almanzar acted with reckless disregard in causing Ms. Ellis's emotional distress if Ms. Almanzar knew that emotional distress would probably result from her conduct, or Ms. Almanzar gave little or no thought to the probable effects of her conduct. If you decide that Amani Ellis suffered damages that will continue for the rest of her life, you must determine how long she will probably live. According to the National Vital Statistics Report, a 32-year-old female is expected to live another 50 years. This is the average life expectancy. Some people live longer, others die sooner. The published information is evidence of how long a person is likely to live, but is not conclusive. In deciding a person's life expectancy, you should also consider, among other factors, that person's health, habits, activities, lifestyle, and occupation. Ms. Ellis seeks damages from Ms. Almanzar under more than one legal theory. However, each item of damages may be awarded only once, regardless of the number of legal theories alleged. You will be asked to decide whether Ms. Almanzar is liable to Ms. Ellis under the following legal theories: battery, assault, intentional infliction of emotional distress, and negligence. Ms. Ellis's claimed damages are recoverable only once under all of the above legal theories. And the verdict form breaks that down for you. The following are specific items of non-economic damages claimed by Amani Ellis: physical pain, mental suffering, and emotional distress. No fixed standard exists for deciding the amount of these non-economic damages. You must use your judgment to decide a reasonable amount based on the evidence and your common sense. To recover for future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, emotional distress, Amani Ellis must prove that they are reasonably certain to suffer that harm. For future physical pain, actually, I think, okay, no, we're fine. For future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, humiliation, and emotional distress, determine the amount in current dollars paid at the time of the judgment that will compensate Amani Ellis for that future physical pain, mental suffering, loss of enjoyment of life, disfigurement, physical impairment, inconvenience, grief, anxiety, and humiliation, and emotional distress. If you decide that Ms. Almanzar's conduct caused Ms. Ellis's harm, you must decide whether that conduct justifies an award of punitive damages against Ms. Almanzar. The amount of punitive damages, if any, will be decided later. You may award punitive damages against the defendant only if plaintiff proves by clear and convincing evidence that Ms. Almanzar engaged in that conduct with malice, oppression, or fraud. If you define that defendant accidentally harmed plaintiff, punitive damages are not appropriate and should not be awarded. In deciding whether or not to award punitive damages against the defendant, you may consider whether defendant's acts were the consequence of a sudden heat of passion that was provoked by plaintiff. Malice means that defendant acted with intent to cause injury, or that a defendant's conduct was despicable and was done with a willful and knowing disregard of the rights or safety of another. A defendant acts with knowing disregard when a defendant is aware of the probable dangerous consequences of her conduct and deliberately fails to avoid those consequences. Oppression means that a defendant's conduct was despicable and subjected the plaintiff to cruel and unjust hardship in knowing disregard of the plaintiff's rights. Despicable conduct is conduct that is so vile, base, or contemptible that it would be looked down on and despised by reasonable people. Fraud means that the defendant intentionally misrepresented or concealed a material fact and did so intending to harm the plaintiff. During the trial, plaintiff testified that she sought treatment from John Scher, MD. It is not in dispute that Dr. Scher has passed away. All right, ladies and gentlemen, that concludes the additional jury instruction.
All right.
And we're back on the record with the court reporter. That concludes the additional
Ready to
jury
roll.
instructions that we are adding to those instructions that I previously read. At this point in time, it is the time for the attorneys to give you their closing arguments. Please keep in mind my instructions regarding the facts in this case. You are the ones who are to determine the facts, and to the extent that the attorneys argue facts that you do not believe were proven during the trial, please rely on your own finding of what the facts are. And similarly, to the extent that the attorneys argue law that is contrary to the law that I've just given you, please rely on the law that I gave you. And with that, is plaintiff prepared to give your closing argument?
Yes, Your Honor. I just ask for a quick sidebar for a moment, please.
Bro, can we get this party started? We're at a sidebar, quick sidebar, and then he is going to give, he being the attorney for Ms. Ellis,
Conversation at sidebar, and now is
going
plaintiff
to
prepared
give closing
to
argument.
proceed with your closing argument as soon as you get there?
Yes, Your Honor, thank you, Graham.
And just for any members of the gallery, if you are not a member of the press and you don't have a sheriff's badge as well, you're not allowed to use any electronic devices or phones. Thank you for that.
Thank you all for coming back today. So at this point, both sides will be giving our closing argument, basically a summation of everything you've heard, just so you can jot down things, take notes if you feel comfortable. So you all heard all of the evidence in this case, and the distinction between a civil case and a criminal case are different. And what that means is, in a civil case, our proof, what has to be in the box, is greater than 50%, touch more than 50%, maybe a featherweight more than 50%, 51%. It's not 100%. The standard is a little bit more than 50%. In this case, you've heard lots and lots of testimony. We've had the plaintiff who's testified. We've had the plaintiff's mother who's testified. We've had the plaintiff's grandmother who's testified. Those three witnesses explained their recollection about the scar. There was testimony that the scar or the cut came from this incident. That's a very, very important fact. There's really nothing to contradict that. If anything, our expert witness, Dr. Mulliken, you remember he came to court. He's a very well-respected doctor that specializes in plastic surgery. And his testimony was that, in his opinion, as an expert, that when the way that this scar, the way that this cut happened was from fingernails, and that there were three different scrapes, three different scratches, and that the middle one was the deepest one, and that's really the one that he worked on. Now, the issue in this case is, well, before I go to that, is the photograph that you saw, okay, which is in evidence. There's a photograph of the scar, which is a 2-centimeter scar. The photograph, because of the skin color, it does not show well in photos. The cut that was on the face does not show up as well. So you may have to really look at it deeper than just had it been someone else. The other thing that I wanted to highlight is I really just don't understand. The defendant came here, used all of this foul language. This is a court of law. You cannot speak this way in a court. I have never seen this before. And for her to use all of those words, F word, B word, all these different words, it's a disrespect to us. It's a disrespect to the judge. It's disrespect to this courthouse. You cannot come to court and say these kind of words. It's just disrespectful. And just because Miss Almanzar, also known as Cardi B, is a celebrity, doesn't mean that she could just say and do whatever she wants and attack people. Okay, if you recall, just to give you a little bit of background about Miss Ellis. When she was 19 years old, she moved out of her house. She went to college. She's a college graduate. She has a bachelor's. She went on to become a security guard for 4 years, from 2014 to 2018. She did whatever she needed to do to become a licensed security guard. And she did that job. And when this incident happened in 2018, that was cut off. She lost her future in security work, in something further, whether it's FBI, police, attorney, whatever she wanted to do. This incident cut it off. No more. Because of the trauma that she sustained. And I get it. There were doctors who gave their opinions. For example, the defense brought Dr. Rosenberg. Nice guy, gentleman. He complimented me. Maybe he's doing that because he's a psychiatrist and he knows what to say to twist everything. But the point is, he got $40,000 to come here and basically tell us that the plaintiff didn't suffer any emotional injury. That's not the facts. The facts are Imani Ellis was working as security guard. There was a change. Okay, it's very, very traumatic to be assaulted and battered. I can only imagine the embarrassment, the emotions, the pain that Miss Imani Ellis suffered. Now, in this case, there was overwhelming testimony that Miss Ellis was working as a security guard at the time of the incident. There's no question. She was in full uniform. She had a badge on. Even the defendant admitted, yes, I understood that this person was a security guard. And there has to be some level of respect. These are not doormen or doorwomen. The defendant, when she came to the building, instead of listening to the plaintiff, to listening to her commands, you got to do this, you got to do that, please leave the building. Different commands were given to her, which none were followed. They were all ignored. Instead, the defendant thought that, Miss Ellis was on her phone. She was telling people that I'm here. These were the thoughts that were going through her head at the time, and she's testified to those. However, that's not the case. Miss Ellis testified that she's never had a fight before. She's never done anything to harm anybody. She's never had any fight with anybody. And her mother and her grandmother also testified. She's a model citizen. She's a hardworking person. And she simply, her whole goal of doing this, to be here and sit here and go through this, is so she could move on with her life. Sometimes people have to be heard. So by you all being here and hearing everything that's gone on, you have given her a sense of closure where she can move on and go on to the next step and the next phase. She's only 32 years old and she has plans. She has plans to do other things in her life. So we're very thankful that you gave us that opportunity. Each and every one of you, we're very thankful. The other thing I wanted to mention is the phone. It would be impossible for someone to be videotaping someone and be on a phone call at the same time. I tried it myself. And the error message that you would get if you tried it is recording video is not available while on the call. So it couldn't be. The two of them couldn't be done at the same time. Miss Ellis told Cardi B multiple times, I am not recording you. I am not telling anybody that you are here. I'm simply doing my job. And instead of maybe agreeing or investigating further, Miss Almanzar, Cardi B got angry and started yelling and cursing and spitting on Miss Ellis and calling her different words, using the N word to disrespect her, calling her the B word, calling her fat, anything to try to trigger her and make her upset and embarrass her. Sometimes words are more painful than the physical. And to add insult to injury, she then cut her face and caused a scar on her face. And what happened then? Miss Ellis had to go see different doctors. The court did read about Dr. Scher, a sentence that basically that it's undisputed Dr. Scher died. And Miss Ellis basically testified that initially, a couple months after the incident, she saw Dr. McKenzie, a psychologist, through her workers' compensation. She was given that. She got 7 visits with that doctor. During that time, she also saw Dr. Scher, who was another plastic surgeon. Unfortunately, we don't have him here. We don't have his records because he passed away. So that's why that was read to you in open court, so that it's some sense of fairness. Why there's no records from Dr. Scher.
Objection, Your Honor.
The worst objection during your closing is horrible.
Then we learned throughout the case that when Cardi B came to the building, she caused a disturbance. She was yelling and screaming at the top of her lungs, going crazy, yelling and screaming to the point where 2 other witnesses, Miss Malcolm, which was the secretary of the doctor, and Dr. David Finke, was so loud that those 2 people came out after about 40 to 50 seconds. Now, the issue with that is those 2 witnesses didn't see the 4 things that happened before that, which happened in the 40 to 50 seconds before. So yes, they're witnesses, but they're not witnesses to that first part, that first segment, which would include taking a swing at Miss Ellis, spitting on Miss Ellis, calling her the N-word, and ultimately cutting her face. None of that was seen by those 2 witnesses.
They would have
So
saw
yeah,
the
they're
scar,
witnesses,
sir.
but they're witnesses to the aftermath.
The
They're
scar
witnesses
doesn't
to
go
what
away.
happened afterwards. They're not eyewitnesses. They don't know what really happened. And when they arrived, Miss Ellis was so upset. Can you imagine all those 4 things happening, being disrespected, embarrassed? Who knows what else happened? All of that was done to her, and she still was able to contain herself to a certain degree. But yeah, sure. I mean, naturally, she was angry. She was emotional. So when these 2 witnesses come out of their offices, they can only see an angry person. They didn't see what led up to that. And they had assumed that it's her fault, maybe, or that she did something wrong. But again, those 2 witnesses didn't really see much. They saw something after the fact. And then you have Miss Malcolm, who decided on her own, this was her choice, to squeeze herself in between the 2 people. Well, that's a risk that she took. And if she somehow got a cut to her face or a scratch or something, well, we don't know who did that. We really don't know. She didn't even know. Miss Malcolm testified that she did not know who scratched her face. She has no idea. What does that mean? It could be from either one. It could be from the commotion that's going on. these things happen so fast, we have no real idea as to what really happened. Unfortunately, there was no video camera there. There was no other witnesses that actually saw it. So it really comes down to one thing. Do you believe Miss Ellis? Why not? You should. She's a hard-working security guard. She was doing her job with no prior anything. At some point during the trial, the defendant showed you Exhibit 232. If you all remember this photograph, Exhibit 232, this is a photograph. Now, the issue with this photograph is there's really no way to know the date that this photograph was taken. There's no way to know. We don't know when it was taken.
Objection.
There is no proof of when this photograph was taken. It could have been taken at any time,
Objection, Mr.
before or after the incident. It could have been, and in this case, the defendant testified that this photograph was taken on the date of the incident.
Objection, Your Honor.
That was her testimony. But where's the proof? Do you really believe that a celebrity can't prove when this photograph was taken? She testified that this photograph was taken at the All-Star, NBA All-Star game. There's no proof of that anywhere. That's just false. There is proof of when this photograph was taken. It just wasn't given to us. It wasn't provided to us. So we can't rely on this photograph because there's no date on this photograph.
Girl, wake up! You in court. She does look pretty. Pretty and tired. They got a sidebar or something. Cardi. Cardi ain't getting no rest last night. Shoot, that's that 3 hours. Well, she got a little extra 3 hours if she stays on the East Coast. But
The next thing that Miss Ellis did is she made an incident report. 2 days after the incident, Miss Ellis wrote an email to her boss and followed what she was supposed to do to explain all of the details of what happened to her. And she did follow company policy and did what they asked her to do. She called her supervisor, made an incident report, and did everything possible to document all of the different things that happened to her on that date of February 24th, 2018. The other important issue is Cardi B testified that she came to the building, at least downstairs at the building. She had a security guard with her, Mr. Newton. Mr. Newton, that's her security guard. He didn't testify in this case. Why not? Where is he? Disappeared? Miss Ellis testified that when she saw this security guard downstairs in the lobby, and she met with him there, Mr. Newton apologized for what happened. Mr. Newton should have testified in this case and could have testified in this case, but he didn't. And there is a jury instruction, KC Jury Instruction 203, which deals with a party having power to produce better evidence. The jury instruction states, you may consider the ability of each party to provide evidence. If a party provided weaker evidence when it could have provided stronger evidence, you may distrust the weaker evidence. That's what the law
you
is.
hit them, buddy.
So where is Mr. Newton? I don't know. He was on the witness list. He should have came here and testified.
come on, bro.
another important fact is, if a witness is not credible on one point, you can disregard their entire testimony. When you go back into the jury room, you will have all of these different jury instructions. And each jury instruction will be there for you where you can read and understand what the law is and how it applies to this case. And as I told you before, testimony is evidence, and you can rely on testimony alone to come up with your verdict. KC 107 states, do not make any decision simply because there were more witnesses on one side than on the other side. If you believe it to be true, the testimony of a single witness is enough to prove a fact. So in this case, you've heard from different witnesses. Just because one side may have more witnesses or less, that's not how it works. One witness is sufficient to prove a fact. You initially heard that Ms. Ellis saw a Dr. Nicole McKenzie. Dr. McKenzie testified. She's a psychologist. She treated the patient in her office, between her and other providers in her office, a total of 7 visits for a period of 8 months. Ms. Ellis did seek psychological care and received it. She also, as I said, went to Dr. Scher. Dr. Scher advised her that he could not do the plastic surgery for a couple of reasons. One is you have to wait at least a year. You have to wait at least 1 year, 1 to 2 years, to determine if the scar will become a keloid. If the cut will become a keloid, if it will become a scar. Sometimes it may go away on its own. In this case, it did not go away. After that time period, if we all remember that in April of 2020, the pandemic occurred. We had this pandemic outbreak where everything was closed. You can't just go and have elective surgery. So the case was delayed. Medical treatment was delayed. That's why Ms. Ellis waited. Another factor is affordability. She had to find a doctor. We had to help her find a doctor that was willing to work on a lien basis. Dr. Mulliken testified that he would agree that he treated her on a lien basis. What that means is she still owes the money. However, in a court case, what happens is the doctor will agree to treat the patient and delay payment. They delay getting paid. That's what Dr. Mulliken did. Dr. Mulliken testified that he fully examined Ms. Ellis. He then decided, with his expertise as a board-certified plastic surgeon, that it would be beneficial for Ms. Ellis to have plastic surgery and have this done in a surgery center. 2 different surgeries were done over a period of 3 to 4 months so that Ms. Ellis could, there were 2 issues. She had hypersensitivity, a little bit of hypersensitivity, and also as a woman, she doesn't want to have a scar to her face. And all the time, every day, waking up in the morning, looking in the mirror, remembering the event, it reminded her. It does remind. Now, the defendant had the ability to hire their own plastic surgeon and have their own expert witness.
I'm sorry.
And in this case, the defendant decided not to hire one. So what does that mean? What that means is you really got to take what Dr. Mulliken says with a lot of importance, a lot of truth. There is no other doctor from the defense side. They could have spent money and hired somebody and had them testify here and tell us, yeah, Dr. Mulliken's work is no good, or she could have done something different, but we don't have that here. You have one doctor on the plaintiff's side basically explaining all of his expert opinions. and he's a board certified plastic surgeon for 30 years. He's
We know what he is.
affiliated with UCLA,
Mhm.
and even testified that he, in his career currently, does teach medical students at UCLA to help them in their careers of becoming plastic surgeons themselves. Now, when you go back into the jury room, you'll see Dr. Mulliken's records and bills that are part of this case. They've been admitted into evidence, and you will see his medical report, and you will see his medical bills. Those are admitted into evidence. You'll have that in the jury room, so you can see it for yourselves. And if you remember, even Dr. Rosenberg had testified that he has seen Dr. Mulliken in other cases. He's been an expert in other cases, working alongside Dr. Mulliken. And this is a very well-respected doctor. He went to Yale Medical School. Even Dr. Rosenberg testified that he had impressive credentials. He acknowledged that fact. And the other thing that I wanted to discuss would be the fingernails. The Cardi B testified that most of the time she would have long fingernails of 3 inches. That's her style. That's what she did. And in this case, not only did she have these long, sharp fingernails, she also had rhinestones. If you remember Dr. Finke, he was a fingernail, that was his thing. And he basically said he remembers the rhinestones, that they were protruding.
Objection, Your Honor.
They were raised.
Assisting.
When Cardi B testified, she acknowledged that she refused to listen to Miss Ellis, who was a security guard on duty at the time. There was also testimony by Cardi B that the two of them were chest to chest, touching. This was a touching that Miss Ellis didn't want. Miss Ellis didn't want to be connected to Cardi B physically, but Cardi B made that happen. And that's an unlawful touching. That alone, aside from the rest, that alone, Cardi B admitted to that fact. She said, that is what I did. I was chest to chest with Miss Ellis. Cardi B even testified that she was yelling and screaming so much that she acknowledged that it was possible that her spit went on to Miss Ellis. That was in the testimony. When Miss Ellis told Cardi B to leave the building, she should have left the building. Miss Ellis was hired by the owner of the building to keep the building secure and safe for tenants and other patients and visitors. Cardi B refused to listen to the security guard who was working there. At some point, Cardi B caused such a disturbance that what she was doing was a trespassing. You cannot be on the property when the owner or an extension of the owner tells you you have to leave. You have to leave. Miss Ellis's mother, Leanne Schmidt, testified She testified that Miss Ellis obtained the scar to her left cheek as a result of this incident.
Objection, Your Honor. Assisting.
She wasn't
Miss
there.
Ellis's mother testified that she recalled seeing the scar after this incident. Miss Ellis's mother testified that she saw changes in her daughter after this incident. Same with Miss Ellis's grandmother, Diane Schmidt. She also testified that she recalled seeing the scar after this incident and that she noticed a marked difference in Miss Ellis after the incident. That's her granddaughter. The defense put on a Dr. Rosenberg, who was a hired gun, received $40,000 for this case and makes millions of dollars in this type of work. He criticized the Kaiser Hospital for not writing down that Miss Ellis had emotional injuries when when Miss Ellis went to Kaiser Permanente for vaginal discharge in 2022. Dr. Rosenberg testified that there was an inconsistency when Miss Ellis went to Kaiser and didn't tell them about her emotional injuries. Why I'm bringing this up is very simple. When someone goes to an orthopedic surgeon, they don't talk about dental injuries. When someone goes to a gynecologist, they don't talk about emotional injuries. What really happens is when someone goes to a psychologist or psychiatrist, they tell them about their emotional injuries. When someone goes to a dentist, they tell them about their broken teeth. When someone goes to an orthopedic surgeon, they tell them about their neck pain, their back pain, their left foot pain, left ankle pain. This idea that every time you go to a doctor, no matter what specialty, you have to cover all these things is not real. It's not real life. Some of the doctors will even say, don't tell me, I don't want to know. I'm not writing it down. We've all gone to doctors, and we all know when we go to a specialist, we'll focus on why we're there. Miss Ellis went to Kaiser Permanente Hospital for vaginal discharge in 2022 and different things throughout her time there. She didn't go there for emotional injuries. She didn't go to the psychiatric care there. She didn't get any psychological care there. None of that. So for Dr. Rosenberg to sit there and tell us there's inconsistencies because in Kaiser, she didn't tell them about the emotional injuries, it just doesn't make sense. I want to talk a little bit more about Miss Malcolm. So I just want to remind you that when Miss Malcolm came out, 40 to 50 seconds had already transpired. She came to the aftermath. I know I've already said that, but I really want to hammer this home that she is not a witness to what happened before. It's like a car accident. There's two cars, they have an accident. If a third car comes down the road a minute later and hits them, it's completely different. It has nothing to do with it. So that was inserted into this case to, in a sense, to muddy the waters, to kind of cloud what really happened. What really happened here in this case is Miss Ellis was working as a security guard. She had to be there. She was working there as a security guard. And Cardi B came along and thought she's above the law. She could do and say whatever she wants and attack Miss Ellis emotionally, physically, and do whatever she wants in a building which is inappropriate. We all know that when we go to a building, you got to be respectful, especially to security guards that are working there. These are not just doormen or doorwomen opening the door for you. You have to follow along with what they say. Next, we heard from Dr. Finke. Want to talk about inconsistencies? There was an inconsistency between Malcolm and Finke. Malcolm said, I don't know how I got this scratch on my forehead. I don't know. Dr. Finke comes out and says that Malcolm told him that Ellis had scratched her face. That's not true. That was never said. So this, if you remember, this is a 7.5-year-old incident, and that's few thousand days ago. It takes a lot of time has passed, and an incident can be perceived differently by different people. So Miss Malcolm could have perceived it one way, and Dr. Finke could have perceived it. But again, same problem with him is when he came, everything already been done. The whole incident already happened. The injury was already complete. And really, this comes down to believing Miss Ellis. She gave you no reason not to. She's been truthful through me and through herself and through her witnesses to give you whatever is there, to provide for you all that she could with the things that she has available to her, so that you could give her the peace of mind, the closure. And yes, she is asking to be compensated for the loss that she sustained. She lost something, and by you compensating her with money damages, you're then evening the playing field. You're giving her what she lost back. So she's not trying to gain something that she's not entitled to. Unfortunately, she was abused, she was harmed, she was assaulted and battered by Cardi B, and Cardi B needs to pay for that and needs to be accountable. We need to hold her accountable. We should not just let her walk away and say, oh, everything you did was okay, and yeah, do it again. Now, in addition to seeing the two plastic surgeons and Dr. McKinsey, Miss Ellis also received another 12 visits of, she testified that she saw a psychologist, Dr. Avila, and other
Objection, Your Honor.
people in his office.
Violation of the court's order.
Move on.
That's a shame. Thank you, Alma S. for the super chat. And not you talking about things that were supposed to be inadmissible. Oh, sir.
The other thing that Cardi B failed to do or could have done is she could have filed a cross complaint.
Objection, Your Honor.
What?
All right. And then I want to go over a little bit about
What? What now?
the medical bills. So you don't have to get it exact. It doesn't have to be an exact number. But there was testimony in this case that Miss Ellis had $17,500 in medical bills from Dr. Mulliken, the plastic surgeon, and another $18,000 in psychological care through her work comp and other things.
Objection, Your Honor.
There was also testimony from Dr. Mulliken that he believed Miss Ellis could benefit from one more surgical procedure, another one, to make it better. The cost of that was $15,000.
Objection, Your
Over.
Looking like a
The
combination.
$15,000 that would be paid for that would, in Dr. Mulliken's expert opinion, it would make the scar better, meaning it would reduce.
Get you some cocoa butter and some aloe vera plants.
There, basically, what I'm saying is there's still some scar on her face, and if you want to look at it, you're more than welcome. You can have her walk around. You can look at it for yourself. There is still some scar on her face. It's still there. It still bothers her. So that's why I'm asking that not only you give her the $17,500 in her past medical bills for the scar, that you give her another $15,000 for the future scar revision treatment. She didn't deserve this. She didn't deserve to be scratched and cut and spit on and all these things. All of the things that happened to Miss Ellis are they're wrong. and we want to make this wrong right. And how can we do that? For each one of you. You have the power to make this wrong right and close the books for Miss Ellis so she can move on with her life as much as she possibly could. And yes, the only way to do that right now for today's purposes is to reimburse her for the losses that she sustained. Those are the medical bills, the past, and the future. The other thing that is an important way of compensating Miss Ellis is for her pain and suffering. In every case where there's medical bills and there's medical damages, component of that is pain and suffering.
What you asking for?
There is really no way, there's no exact math to that. So for instance, if you said, I want to give her the $17,500, I want to give her the $15,000, and I want to give her another $250,000 for pain and suffering, you are allowed to do that. It is a number that you can come up with. During the 7.5 years that she's been suffering, you may say, I would like to give her $100 a day. For 1 year, that's $36,000. And for 7 years, that comes up to $270,000. We're not looking for millions of dollars like the defendant said. That's not what we're looking for. We're really looking for a simple amount of money that can make her whole, give her something that's fair so she can get some form of compensation, some form of closure, and move on with her life. That is all we're asking you to do.
Is that it?
So when you go into the jury room, you'll be given a verdict form. And the verdict form will basically state, it covers all of the different areas of this case. The first section A is the assault and battery. They are in a sense separate because the assault is the swing and the battery is the scratch and the cut to her face. However, it's very clear. Did Plaintiff Imani Ellis prove all of the following elements of battery? And then it goes down, it breaks it down. Defendant Belcalis Marlenis Almanzar touched Miss Ellis with the intent to harm or offend Miss Ellis. Miss Ellis did not consent to being touched. Miss Ellis was harmed or offended by Miss Almanzar's conduct. A reasonable person in Miss Ellis's situation would have been offended by the touching. I would say that yes, all four of those have been done here. So when you get to that question, there is going to be on the right side, it's not broken down into 4 parts. It's all as a whole. So if you want to give money damages to Miss Ellis, you would check yes. Okay, and then you go to the next question. Did Miss Ellis prove all of the following elements of assault? And again, it breaks down for you the 5 different parts. Miss Ellis acted with the intent to cause harmful or offensive contact with Miss Ellis. Miss Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner. Miss Ellis did not consent to Miss Almanzar's conduct. Miss Ellis was harmed, and Miss Almanzar's conduct was a substantial factor in causing Miss Ellis's harm. Again, if you want to give her money damages, you would check yes. That would be page 2, both of those. Then you have question number 3. Did Miss Almanzar prove all of the following elements of self-defense? So the defense is trying to argue that all the things that Miss Almanzar did were in self-defense. There is no testimony of self-defense here. In fact, Miss Almanzar herself, her position was, I didn't touch anybody and nobody touched me. So self-defense No, you would say no. Then you can go, then question number 4 speaks about the damages that she suffered. Past medical expenses. That's where you would put in an amount of money through the testimony that you heard and through all of the exhibits. You would put an amount of money that you believe Ms. Ellis incurred in this incident. So you will have in the jury room exhibit number 4. You'll have exhibit number 4, it's been marked at the bottom right corner. You will have exhibit 4-1 through exhibit 4-6, and then it will skip over and you will go to the bills, which will be 4-13, 4-14, and 4-15. If you combine all of these bills, you will get $16,500. So past medical expenses would be $16,500. That would be what you would write there if you want to give her the cost of all the plastic surgery she had to go through up until now. The future economic loss is the future plastic surgery. Dr. Mulliken stated that Ms. Ellis would benefit from a future plastic surgery of $15,000. So you would write $15,000 in that box. Pain and suffering. Again, there's past pain and suffering and future pain and suffering. The court read a time frame for you of how many more years Ms. Ellis will live. And the jury instruction life expectancy, 3932, basically states that Ms. Ellis will live for another 50 years. This is an estimate. It's not 100% certain, but it's the best estimate that we have based on all kind of statistics. She has 50 more years to live. So if you feel that she's going to suffer from this point forward, then you can award her money damages for the future. And if you feel that she sustained pain and suffering in the past, then you can award her money for the 7.5-year time period. And again, you'll all have the jury instructions in the back when you go into the jury room. And the jury instruction on pain and suffering covers a whole bunch of different things. Very important. Very important. So I would take a look at that one because it covers all of the different things. Embarrassment, pain and suffering, disfigurement, all of those. So if you look at 3905, it talks about physical pain, mental suffering, and or emotional distress. And it basically says that there's no fixed standard for deciding the amount of these damages. This is a number that you will come up with. It won't be based on chance or a flip of a coin, but it will be a number that you come up with. If you decide you want to give her $500,000, you can do that. If you want to give her more, you can do that.
That's the scar.
So for past
So for
non-economic
1,000
loss,
of you, hit the like button for me. Subscribe to the channel. That would be nice
you
too.
should put a number there.
Comment in the chat.
Because if you don't, the award will be thrown out. You got to have at least $1 there. You got to award some kind of pain and suffering. It's required. Now, the amount would be up to you. A lot of times, some people say, well, 3 times medical bills, 10 times medical bills. This is an assault and battery. It's just not a simple car accident where it's just, some bumps and bruises. This is a serious, serious injury, very serious. And Miss Ellis has been suffering for the last 7.5 years. What kind of weight do we put to that? What kind of number do we attach to that? I don't know what number you're going to attach to that. But for purposes of now, for example, you could write $250,000 for the past pain and suffering. This was a violent attack. She was violated. She has a scar to her face now. She's gone through all kinds of medical treatment that she didn't have to go to. So much life was lost from her, time-wise. You can't get it back. All this time that she's lost and feeling embarrassed and all of that. What is the value of life? It's significant. We all went through the pandemic. We all went through the pandemic, and we realized that after the pandemic, the value of life is much greater because we realized what life is really about. Future non-economic loss. Again, that's going to be for the 50 years going forward. You could pick what number you feel. Maybe you feel she's recovered. Maybe you feel she deserves another 10 years. Maybe the whole 50 years. I don't know what it is. But you as individual judges will work together as a team to come up with a number for the future non-economic loss. Then it goes into intentional infliction of emotional distress. Did Miss Ellis prove all the following elements of intentional infliction of emotional distress? Number one, Miss Almanzar engaged in extreme and outrageous conduct beyond mere insults, threats, indignities, annoyances, hurt feelings, or other trivialities that a reasonable person is expected to endure. Miss Almanzar intended to cause Miss Ellis emotional distress. Miss Ellis suffered severe emotional distress, and Miss Almanzar's extreme and outrageous conduct was a substantial factor in causing Miss Ellis to suffer severe emotional distress. If you believe that Miss Ellis sustains emotional distress, then you would, on number 5, you would say yes. Then number 6, again, it says, did Miss Almanzar prove all of the following elements of the privileged conduct defense? So again, it's similar to a self-defense of this, and it goes through a whole laundry list of different ways and finding excuses why the conduct was okay. So you would put no there if you believe that the conduct caused intentional infliction of emotional distress. Then number 7 has its own damages component. However, we've agreed and conceded to the fact that we don't want you to award damages for the same thing twice. It's not what our goal is. The goal is if you feel there should be separate damages aside from the assault and battery for the emotional distress, then this is where you can give that amount of money. It'll be a separate and apart damage area for you to award more damages. The same breakdown. You can give past medical expenses, obviously, past and future medical expenses. In this, if you're awarded in the first box, then you would say, 0 and 0, because we're not double dipping here. That's not our goal. However, pain and suffering. If you want to give separate pain and suffering for the emotional distress, separate pain and suffering for the emotional distress from the past and the future, this is where you could do it. You could say, okay, well, we're going to give $50,000 additional for the past, $50,000 additional for the future, and then we're going to move on to the last part, which is negligence and contributory negligence. And again, this is all from the form that you're all going to see when you go into the jury. And I'll close with this. Did Miss Ellis prove all of the following elements of negligence? Miss Almanzar was negligent. Miss Almanzar's negligence caused Miss Ellis to suffer physical harm rather than only emotional distress, and Miss Almanzar's negligence was a substantial factor in causing Miss Ellis's harm. So what that means is, for example, was Miss Almanzar Was Cardi B negligent in thinking that the plaintiff was disseminating her privacy to others, photographing her, videotaping her? If you believe that Miss Almanzar, Cardi B, was mistaken, then that would be negligence. She was negligent. She negligently thought that all these things were happening. And then again, it asks for the damages. Same thing. 0 and 0 for the past and future medical expenses if you have given it in the first phase. So there's different areas. Maybe you'll say, well, I don't really believe there was this, but I believe there was that. So anywhere on the form, we would ask that you award Miss Ellis her medical bills of $16,500 for the past and $15,000 for the future, and in different boxes and different areas of this form to award her the pain and suffering that you feel is fair for all the things she went through, the assault, the battery, the emotional distress, all that she should be compensated for.
So the ex-employee was originally on the lawsuit. I don't know what happened with that.
And then there's a box, did Miss Almanzar prove all of the following elements of contributory negligence? Miss Ellis was negligent. Miss Ellis' negligence was a substantial factor in causing her own harm. Well, Cardi B testified that Miss Ellis didn't touch her, didn't do anything. There was no physical contact. That was the testimony of Cardi B. So how can she say that there was contributory negligence? What did the security do wrong? So the answer would be no. And then it goes to number 11. What percentage of responsibility for Miss Ellis's harm do you assign to Miss Almanzar? Say 100%, and Miss Ellis, 0.
Okay.
And the final page deals with punitive damages. Did you answer question 4 or 7? And you look back and if you did, which is the damages, then you put yes. And then it says, did Miss Ellis prove by clear and convincing proof that Miss Almanzar engaged in conduct with malice, oppression, or fraud? And then you would look at the case as a whole and kind of come up with your opinion. Did all of these things combined, did all of this thing that Miss Ellis went through? And remember, it's or, so it's either malice, oppression, or fraud. So if you agree that there was, then you would say yes here. So at this point, I'm going to turn it over to my counterpart.
Thank you.
They will obviously contradict everything I will say. I've told you. And then I will have a chance to come back and rebuttal and basically clean up anything that was said. At this point, I'm basically Miss Ellis's mouthpiece, and I worked with her as best I could to convey all of the things that she wants you to know. I worked with her personally to tell you all what she went through, and I did the best that I could with what I have. And we really, no matter what happens, no matter what happens, whatever is supposed to happen will happen, because that's what's supposed to happen. And
What?
we want to thank you each individually for being here. Each of you as individual judges, we're thanking you very much. Thank you so much for hearing the story as to what Miss Imani Ellis went through. And I'm asking you to award Miss Ellis an amount of money that you think is fair, that will make her whole for the losses that she suffered in this case. Thank you very much.
All right.
You, counsel?
Yes.
You okay? You want to take a break? You okay? Okay. All right. Is the defense ready to proceed?
We are, but I would think a break would be appropriate at this point.
Does anyone want a break? We got started late. Okay. Why don't we take a short break? Why don't we resume back at 11:25? In the meantime, please not discuss the case with anyone, including other jurors. Don't form any opinions or do any research. We'll see you at 10:25. Or I'm sorry, 11:25.
Well, that was the whole hour. What do you guys think about the closing? Do you think that he did it for you, that he tied it together, and now you understand why Miss Ellis filed this lawsuit based on this here scratch right here? This is what this is all about. If you look closely, I guess you can see a little scratch over here, little webs. It looks like going down here. But they not saying the testimony elicited doesn't sound
If I'm not
like
fair, it's
intent.
probably, I wasn't going to get into it, it's generally not proper to include yourself in terms of what we all went through, but that's why I was overruling the objections. One note, and is this grandmother here?
Yes.
Ma'am, can I have you step forward? Can I have you step forward?
What happened? Or something happened to what he said.
And ma'am, you were previously sworn. You understand you're still under oath? Did you have any conversations with alternate number 1 on Wednesday? The woman on the corner? The woman who's on the jury.
Oh man.
You don't recall any interaction with her?
She sat next to me and she was waiting on a break, but we didn't speak.
You didn't speak with her? Okay. So you didn't talk to her about the trial at all?
Absolutely not.
Okay. All right. You were just seeing, we thought that there may have been some discussion between the two of you. You don't recall that? Okay. All right. Thank you. All right. Something else?
Yes, Your Honor. Although you cautioned counsel that he can't argue things that are not in the evidence, he repeatedly did. He even started talking about Dr. Avila's treatment, even though he was excluded, over and over and over again. And all the jury sees is me objecting and Your Honor sustaining it. I would request that you would want the jury to disregard all of the statements that you sustained objections to. I would also ask that you assign misconduct to counsel and that he be reprimanded because this has just been ongoing.
Okay. We can discuss.
I want to respond.
Well, let me do this. I will give further instruction to the jury about that the argument of counsel is not evidence and that they should disregard any comments that were not supported by the evidence. I will give that instruction. We can discuss whether or not we want to set an OSC after the trial for any alleged conduct. Okay.
Thank you.
Your Honor, may I please say one thing?
Yeah.
Please.
Go ahead.
I just want to note that you advised Mr. Rosen that if he were to argue to the jury that Cardi said that photograph was taken on February 24th, that would be a knowing violation of the professional rules. And that's exactly what he did.
Okay.
Yeah,
Well,
I wanna respond.
why don't we? I don't want to do it now.
Well, I have to say something about it.
You don't. I said we'll discuss whether or not we want to set an OSC and we can address it then. Okay.
Thank you, Your Honor.
All right.
So that's an order to show cause why he shouldn't be held for contempt for his misconduct. That's what they're thinking about doing. There's the scar for those of you just coming in. It's over 1,000 of you guys. If you guys are enjoying the commentary, the content, please make sure you hit the like button and subscribe to the channel. And please, engage. We'd like to talk over here, okay? Engage. Give us your opinion. We learn from each other. As you guys see the closing argument, so one of the questions that I saw repeatedly is a comment for objections. It's very, very rude. It's one of the worst things I think to do. I mean, there's several things that could be done that's probably worse, but out of courtesy, you typically don't. This is why Cardi's attorney initially asked, listen, could you tell him to make sure he doesn't make me have to object, because you still have to protect your client and protect the record. And this information is being heard by the juror. So I remember one time in trial where they objected in my opening. We went and we did a sidebar and the judge went off on the other side and was like, I don't like, unless she's just doing something downright, that has not been shown or whatever, don't do that again. So you get some judges that can't stand that. But if you get to a point where you have one side saying, I basically believe that the other side is going to try to enter evidence or say evidence that wasn't entered into evidence as if it was, or go against the motion in limines, of which we talked about. Motion in limines is when you try to deal with evidentiary evidentiary issues pre-trial. So what you do is you try to say a motion in limine to exclude the testimony of Dr. Smith. Motion in limine to exclude, which happened in this case, other bad acts. That's why I was upsetting to the other side when he mentioned gang affiliation. He immediately just talked about, are you a part of a gang? That was a part of a motion in limine. So it shouldn't have been talked about. So he, even though they've had some of these evidentiary hearings where evidentiary issues where he's lost, he's still bringing them up. So now Cardi's attorney is asking, hey, can we let me take her off. Let me take her scar off of here. Hold on. Is asking for instruction to the jurors related to disregarding anything that was sustained. And you may have the bad part about objections is, and this is why you try to get those issues resolved, because you don't even want the question coming out. Because sometimes people look at it when you object, what are you hiding? Why are you objecting? What are you hiding? What information are we don't know how that can affect or taint a jury. So you try to exclude information that you can readily, it's readily apparent it's going to be inadmissible, and the judge will tell you don't even bring it up. This has happened repeatedly, apparently, in this trial, of which there were motion in limines, there were information of which was not into evidence. He's just talking like he's talking on the phone. You can't do that in closing. You cannot. You have to put what what was entered into evidence rendered admissible. It doesn't matter even if you got some evidence that you feel like you have. If it was not admitted in this trial, you cannot talk about it in your closing. You can only talk about the exhibits and testimony that was admitted and elicited in trial. This is why you got objections of mischaracterization of the testimony. Like saying the grandmother testified that the scar came from the incident. She can't testify to that because she was not there. So why is her testimony? It's very interesting how her testimony, grandma's testimony, should be admitted as far as she saw the scar after this alleged incident occurred. But you're saying the doctors and them who came maybe 20 seconds after the incident, their testimony shouldn't be admitted, the doctor and the receptionist, because they weren't there. Well, they can see a scar. The scar wasn't going to disappear. So it's like you want the jurors to believe the familial relationships, of which, of course, regardless to what it said, they probably are going to side with their relative on, yeah, she said it was, it was right after I saw a scar on her face right after that incident. But then you're saying the doctor who came out there after the fact, who said, I didn't see one scar on her face. They both were cussing each other out. And I got her fired because it was unprofessional and it shouldn't have happened. And she wouldn't calm down. Cardi went in. How you acting like you're the victim, but you won't even calm down? The doctor had to literally, he said, like, guide her to the elevator so that she could get back on her post. So anyways, that was the plaintiff, Miss Ellis's closing arguments. Now, after this break, we will have the defense. Thank you. It's over 1,000 of you guys watching. Make sure you hit the like button. Thank you so much for watching it with us. I know there are, we're streaming it from somebody else's platform, so we know other people are streaming it. So we're just grateful that you over here with your girl. All I ask is that you hit the like button. And if you want to subscribe to the channel so that you can follow us as we talk about other legal cases, please make sure you do so. That is Miss Ellis's grandmother. And then towards the end, as you guys saw, allegedly there must have been some type of, somebody perceived that there was a conversation that happened between an alternate juror and grandma. So it had to be obviously questioned and addressed. She was trying to put Cardi out of the bill. But do you got that right to do that? You know what I'm saying? Like, typically, if there is something and you ask them to leave the building and they don't, let's just assume that happened and she said, leave the building now. You can get up out my building. Like was said, Cardi said, she said that, get up out my building. You don't own the building. That's the first thing. Secondly, if someone does not leave, you don't put your hands on them. You call the police. That's kind of how that works. If you felt like somebody was a disturbance, I think she might have started throwing her little weight around when Cardi was getting back with her or whatever happened. However, do I believe an argument happened? Yeah, I think they was cussing each other out for filth. But Cardi didn't feel like it was a big deal. Could it have been she accidentally got scratched? Maybe, but that's not intentional. That's not an assault. Assault is an intentional tort. It has to be intentional. What they described was not intent. That means she would have had to be like, and like of the intent of really like committing a battery. The information they got out was, even with the spitting, that's not intentional. If you're saying she was talking and spit came out, that was not intentional. That's them yelling on each other, at each other. And Cardi was honest and said, if spit came out, I don't know. And he wants to use that to say that she spit on her. No, spitting is, I'm purposefully trying to nastily spit on you, which is aggravated assault from a criminal perspective. So anyway, 80% CMOS said not to mention how you're going to put her out when she could have been having a medical emergency. Exactly. They're trying to paint a picture that she was just paranoid about the whole recording. The thing was, if you went the opposite direction of Cardi, none of this would have happened. When you saw her and she said, why are you recording me? If you weren't recording her, it shouldn't have been a back and forth conversation. You should have hightailed yourself back on that elevator and went to your post. That's what you should have did. Because it ain't had nothing to do with you. She was there for a medical appointment.
When we left the courtroom, Mr. Peterson made some remarks to me that were rude.
Why don't we do this later?
Look at them going back and
I
forth.
ignored him, I didn't talk to him.
Okay, all right, we're gonna bring in the jury.
That's complete falsehood.
It's Mr. Anderson.
Look at them going back and forth. Stop acting like you're losing, plaintiff. You cannot lose your cool, all right? He's not happy about the prospect of a potential show cause hearing based on his behavior. To me, they're not explaining why she didn't just go to her post and keep it moving. Let that lady go. She may have had some hormone issues. She may be paranoid because she's a celebrity. You might be right, but why argue and engage with her? I'm not recording you. Oh, I am recording. My bad, or whatever she said. You should have got yourself on that elevator and you should have left. It's like you wanted to get in an altercation with her so it could be something to talk about or something to sue for later. That's what it's giving to me.
All right, welcome back, everyone. We're back in the record in the Ellis matter. Counsel and the parties are present, as are the members of our jury and our alternate. And before we get started with the defense closing argument, you heard a number of objections during plaintiff's closing. Some were procedural or evidentiary in nature, but some of them were based on facts that weren't introduced during the trial. And so that's why I was sustaining those objections. To the extent that plaintiff's counsel mentioned any facts that weren't presented in evidence during the trial, please disregard any and all of those facts that he represented that weren't actually accepted into evidence during the trial. Okay? All right, with that, defense can you give their closing?
Thank you. Good morning, everyone. I'd like to start by thanking all of you for taking the time to participate as jurors. This is how our system works, and it wouldn't work without jurors. And I'd like to thank you on behalf of both Cardi, my colleagues, and myself. I'd like to just mention quickly that counsel argued that Cardi swore and used profanities in the courtroom and that was disrespectful. Actually, all she was doing was repeating under oath what was said. In fact, Ms. Ellis, plaintiff, used profanities to describe what she heard. Counsel used profanities, and I have to admit I used profanities, but just to tell you what was supposedly said. Cardi has never gratuitously sworn at any point in this courtroom, and the suggestion that you should be prejudiced against her because of that is just unfounded and offensive. Last Monday, it seems like it's a lot longer ago, but last Monday in the opening statement, I told you what I expected the evidence would be. And I told you that you can treat my statements and counsel's statements as promises of what they were going to show. And that I would ask you at some point today to decide who kept their promises and who didn't. I also told you that I would have a second chance to talk to you directly after all the evidence is in. The evidence is in, witnesses have testified, that exhibits have been admitted, and if you remember, the judge told you the first day that the way trials work is that bits and pieces of evidence come in. This is my opportunity to tell you how we think those bits and pieces come together and how they establish that Cardi, you should decide in Cardi's favor. First, there's a couple of things I ask that you keep in mind throughout the rest of the trial. If you remember, Judge Fusselman told you last Monday morning that the reason we have juries is because they have diverse backgrounds and they have common sense. He reiterated how important common sense was when he said, we just need you to exercise common sense and evaluate, is this witness being consistent? Is this witness saying things, something that doesn't seem true? And does this piece of evidence fit in with all the other pieces that have been presented in this case? I respectfully suggest to you that using your common sense, there's only one possible outcome in this case, and that is a decision in favor of Cardi. Now, you'll be instructed that plaintiff bears the burden of proof of establishing her claim. She must convince you that the evidence shows that by 50% or more, her claims are valid. Now, there's another way of putting it is, and you'll see this in the jury instructions that you get from the judge, if plaintiff fails to prove that her version of what happened is more likely than not what did in fact happen, you must decide the case in Cardi's favor. The concept of a preponderance of the evidence can be demonstrated by this slide. That's 50-50. That's where the plaintiff has put on as much evidence as the defendant of a fact, and you'll see that that's where people talk about the 51%. But it is crucial to keep in mind that plaintiff doesn't start at 50%, she starts at 0. She has to raise that needle from 0 to 50% and more. She has to go beyond 50%, or you have to find for Cardi. Third, there is no dispute that there was yelling and some curse words in the hallway at the medical building around 1:30 p.m. on February 24th, 2018. But the judge will provide you with the jury instructions. In fact, he already has, that arguing, yelling, even using profanity is not something you can sue over. That's just part of normal life, and that is what we're supposed to bear. In fact, that would be crazy that someone could sue if they cause someone else to use profanity. The question really is whether Cardi ever struck plaintiff, and who caused this confrontation, who caused the incident. And the answer is that the evidence in this case overwhelmingly proves that Cardi did not strike plaintiff, and Cardi did not cause this encounter. As a result, plaintiff has failed to establish, by the evidence you heard last week, that by a preponderance of the evidence, more likely than not, that Cardi was the cause. The way, I'm going to try and do this in a very organized fashion, and the way
Thank you.
I'm going to do it is going to be demonstrated by this chart. And
That's
so
right,
we
keep
have on
working
the
on it.
left-hand side plaintiff's evidence, then on the right-hand side defendant's evidence. Now,
Can we-
plaintiff started with her own testimony. Last Monday, she testified under oath. Importantly, though, in plaintiff's evidence, she never called as a witness either Tiara Malcolm or Dr. Finke, both of whom were present.
Objection, Your Honor.
Both of whom were present at this very time of the incident. Now, plaintiff's evidence, plaintiff's testimony, and we should keep in mind that just because plaintiff says something doesn't make it true. Okay? She has her version, but the fact that she alone says it does not actually make it true. And later this morning, maybe stretch into afternoon, I'll tell you, or I'll identify the many inconsistencies in plaintiff's story over the course of this litigation, actually going back to February 26, 2018, when she did her incident report. In the meantime, plaintiff claims that she was assaulted and scratched or cut on February 24, 2018. But plaintiff did not see a doctor. She didn't go to an emergency room. She didn't call the police or make a police report.
Objection, Your Honor. Misstatement.
And she actually testified she did not know if the scratch that has supposedly ruined her life was even bleeding. She also testified last week that she didn't even put a Band-Aid on the scratch. What did she do? She claims that Cardi mauled her, basically, cut her face, and this woman went home, and what did she do? She took a nap. That was her own testimony. She took a nap. The fact that on February 24, 2018, plaintiff just went home and took a nap is corroborated by plaintiff's own T-bill cell phone records for that day. As you'll see, and this was an admitted exhibit, you'll be able to see it, it's exhibit 200. She gets calls and she makes calls from 11:20 a.m. all the way to 3:35 p.m. and then nothing until 9:08. That's when she took her nap. That's what she did. She didn't call a doctor. She didn't go to the hospital. She didn't put a Band-Aid on her face. She took a nap. Now, importantly, when plaintiff testified as her own first witness in her case, she admitted that in 2021, she hit her head in a car accident. She's put on no proof that that wasn't the source of the scar, which is a pretty obvious reason that she would have a scar if she had one. And importantly, 2021, a car accident in 2021 is after plaintiff told Dr. McKenna in April 2018 that Cardi almost touched her with a fingernail. Not touched her with a fingernail, and I'll talk more about that later, but almost touched her. So after the plaintiff tells Dr. McKenna, her workers' comp physician or psychologist, that Cardi almost touched her, plaintiff was then in a car accident, hit her head, and that's when she went to Dr. Mulligan. She went to plastic surgery 4 years later after being in a car accident.
Objection, that misstates.
Plaintiff also testified, by the way, that she was in another accident in 2023 and filed another lawsuit over that one. Plaintiff has argued, and he said again today that plaintiff's counsel has argued and said again today that plaintiff has some special status as a security guard. But she testified she became a security guard by having her fingerprints taken and sent to California. That's it. That doesn't make her a policeman. Also importantly, when testifying last Monday, plaintiff admitted that she knew on February 24, 2018, that Cardi was in the medical building because Cardi was going to a medical appointment. Plaintiff's own testimony establishes that at 1:30 p.m. on that Saturday, plaintiff could have been at that security guard booth that counsel showed you a photograph of. She could have been on her rounds, going through the whole building. She could have been in parking, checking, because that's what security guards do. But plaintiff, who has testified she was a fan, just happened to be outside Dr. Finke's office when Cardi B was showing up to see an obstetrician. From those facts alone, you can infer that she was actually laying in wait. She wanted to photograph and videotape Cardi. She would then be able to post it on YouTube, maybe start a new career, be a follower, I don't know. But from the facts you've seen in this and heard in this case, she very well could have done that on purpose. But even if we assume that plaintiff just happened to run into Cardi B in a 5-story building that afternoon, plaintiff testified that she knew Cardi thought that plaintiff was using plaintiff's phone to tell someone that Cardi was there and to videotape her. What would a reasonable person do at that point? By her own testimony, plaintiff had the chance to be professional and avoid all of this by putting her phone away. That's all she had to do. But the evidence is she kept that phone in her hand all the way through as she advanced on Cardi B and forced her into a corner in the hallway where Tiara Malcolm found her. Plaintiff also testified that after she was fired as a security guard, she got a new job that paid more money. That's why you don't hear any claim for lost wages or anything like that. She was better off.
Actually, not claiming lost wages.
That summarizes what plaintiff testified to, and I'll talk later about the inconsistencies in it. But let's talk about her second and third witnesses, plaintiff's mother and grandmother. Both very charming. But her mother and her grandmother weren't in the hallway that afternoon. Her mother and her grandmother were not witnesses. And they testified that because plaintiff is the mother's daughter or the grandmother's grandchild, that they believe her. They don't need evidence. They just hear what she says. And that's understandable, of course. We all have relatives and we hope our parents believe us and and our grandparents. But remember what Judge Fusselman said at the very beginning, common sense. Okay. We all know that parents are not with their children every minute of the day. We all know that children don't always tell their parents everything. And they especially do not tell their parents that they're embarrassed or guilty about what got them fired. That's what plaintiff left out when she talked to her mother and her grandmother. Is anyone surprised that plaintiff did not tell her mother and grandmother that plaintiff cursed and yelled at a pregnant Cardi, half her size, that plaintiff cornered Cardi in a medical building hallway, and that plaintiff knew she was probably going to get fired? Is that the kind of thing you'd say? Guess what, Mom? Guess what I did today? So it's completely understandable, using common sense, that the mother and grandmother would not know actually what happened. In fact, plaintiff didn't tell them that she had apologized in her incident report to Allied and the building for her own behavior. She left that out because I asked both the mother and the grandmother, did your daughter or granddaughter, tell you that? And they said no. So we know that plaintiff left that part out. Plaintiff's mother and grandmother both said that plaintiff is a peacemaker. Okay. Well, that sure doesn't square with the testimony of Tiara Malcolm, Dr. Finke, or Cardi, and I'll discuss that later. And maybe what we take from that is she's a peacemaker when she gets her own way. We know what she's like. We've heard testimony what she's like when she doesn't get her own way. But there's another word for that other than peacemaker. It's a bully. Plaintiff's mother and grandmother both said they saw a scar on plaintiff's cheek. But on February 26, 2018, 2 days after the incident, plaintiff emailed her incident report to her supervisor, Jasmine, stating that Cardi scratched plaintiff's nose. So how is it that the mother and grandmother are saying that, well, when this happened or around that time, our daughter said that Cardi had scratched her cheek? But in plaintiff's own incident report, she said she told her supervisor, Cardi scratched her nose. A nose is not a cheek is not a nose, and there is something wrong about what's going on because, again, apply common sense. Plaintiff's mother testified that she saw a scar, but she didn't testify when she saw it. Counsel asked her, did you notice after the incident that Imani Ellis had a scar to her face? Answer, I did. When did she notice that? 2018, 2019, 2020? We don't know. And in response to one of your questions, because the judge was kind enough to allow jurors to ask questions, which doesn't happen all the time. You're lucky in that regard. One of your questions, the judge read, and in response, plaintiff's grandmother said she spoke with plaintiff right after the incident. Right after the incident, she spoke with plaintiff. But plaintiff testified last Monday, question, you didn't call your grandmother though, did you? Answer, no. Okay. So again, common sense tells you something is very wrong here. Now, plaintiff's mother and grandmother testified that plaintiff became depressed. If so, there could have been many different reasons for it. And for example, it could have been because she got fired. And as we'll see in a few minutes, she felt guilty. That's what plaintiff told Dr. McKenna in April. On April 26, 2018, plaintiff told Dr. McKenna that she feels guilty. Ultimately, the testimony of plaintiff's mother and grandmother just doesn't move the needle for plaintiff. They weren't there, and they're relying on what plaintiff told them. Now, plaintiff's third group of witnesses is Dr. Mulliken. And that's what she offered to support her claim. Of course, Dr. Mulliken also wasn't there on February 24, 2018. He didn't witness what happened. Dr. Mulliken testified that plaintiff came to him in November 2022, or more than 4 years after the alleged incident. Dr. Mulliken is a plastic surgeon, not a psychiatrist. So counsel pointed out that Dr. Mulliken testified that plaintiff told him she has post-traumatic stress, anxiety, depression, and headache. But Dr. Mulliken said, that's what she told me. I did not make a diagnosis to that effect. That's just what she told me. Now, Dr. Mulliken, and I hope he's not insulted, but his testimony was confusing and inconsistent. He testified that in November of 2022, plaintiff had a scar, had 2 to 3 scars, had 3 scars, and even plaintiff doesn't claim that she has more than 1 scar. But Dr. Mulliken thought there were as many as possibly 3. Somehow the no scar from the beginning turned into 2 scars and then 3 scars. Also, though, Dr. Mulliken's own photograph, Exhibit 228, which he testified was taken with a digital camera before any treatment, sure doesn't appear to show the scar. That is you'll have a copy of the actual photo. It's admitted as exhibit. You can look at it and you can decide. Counsel actually challenged you, look at the photograph, and we invite you to. If you see a scar, that's news to us. And this is before she was treated. Importantly, Dr. Mulliken testified at his deposition. You've all heard about depositions. They're under oath. It's just like a trial, except there's no judge. And that the claim scar was about an inch long and most likely made by a right-handed person who scraped or clawed downward with 3 fingers. Okay, that's what he testified to. That's what was in his deposition, and that's what he testified to here. But plaintiff herself claimed in her deposition that Cardi jabbed her with a straightened index finger, like this. That's not a scrape. Your Honor, I don't think I need to ask for permission, but we'd like to show then we'll show, this was played for the jury before. It's Cardi's testimony, plaintiff's testimony, as to how she was supposedly cut by Cardi.
When you say like this, she put her finger.
Pointing, yes, so like this, pointing her finger in my face, yes.
That is directly and irreconcilably in conflict with Dr. Mulligan's testimony that it was a right-handed person who scraped with an index finger and two other fingers downward. Those are completely different things. They don't correlate. The testimony is clear that plaintiff and her plastic surgeon have completely different explanations for the same claims scar. And once again, common sense. Something's wrong here. Something is very, very wrong. Now, maybe the scar that Dr. Mulligan says he saw and his explanation, maybe it was a car accident. I don't know. But it is irreconcilable with plaintiff's own testimony that she was jabbed with the straightened finger. And to add to that, Cardi is not right-handed. I want to say that again, it's very important. Dr. Mulligan says that in his professional opinion, and counsel talked about how well respected he is, that it was a right-handed person who scrapes three fingers downward across plaintiff's face. But Cardi is left-handed. She is not a right-handed person and could not have done that. Plaintiff's counsel tried to get Dr. Mulligan to testify that a left-handed person might have made the claim scar. But that's not his opinion. He admitted that it would be hard, in fact testified it would be hard for a left-handed person to reach across and strike a person on the opposite them on the left side of the face. Now, here's another important thing. Dr. Mulligan testified that he can't say when plaintiff got the claimed scar. He testified there's no way of knowing the age of the scar. That's important because plaintiff admits that she hit her head in a car accident in 2021, almost 2 years before the November 2022 appointment with Dr. Mulligan. And Dr. Mulligan also testified that he can't say whether the claimed scar was caused by an intervening accident or some other cause.
Objection, that was Stacy testimony.
You heard the evidence. Please rely on your recollection of the evidence and rely on your own recollection to the extent that it differs from counsel's representation.
And Your Honor, we also have a cite to the reporter's transcript. There are other odd things about Dr. Mulligan's testimony. For example, he calls a 3-minute long session of outpatient microneedling a small part of plaintiff's cheek, which serves, well, as reconstructive surgery and plastic surgery. A 3-minute microneedling session in his mind is reconstructive surgery and plastic surgery. Now let's talk about why he would say that. He has a broad version of surgery that enables him to charge an additional $11,000 for an operating room. He testified surgery is anything that includes a doctor, a nurse, a scrub technician, and an operating room. No matter what you're doing, even if it's microneedling, if it's pulling a splinter out, you go into that room and he charges $11,000. Dr. Mulligan testified he is the sole owner of the surgery center with that operating room. So he has a strong financial incentive to use and charge for that operating room, whether he's doing real reconstructive surgery or microneedling. Now, perhaps because his photograph doesn't seem to show the claimed 1-inch scar, Dr. Mulligan also provided confusing testimony about hidden scars under the skin. I don't know if you remember that. It had my head spinning. But he never testified. There's no testimony from Cardi, from Dr. Mulligan, or anyone else that plaintiff has a hidden scar. In fact, it's supposed to be this, really big embarrassment that she has this, terrible scar on her face that, you can decide whether you've seen it. You've walked by her. If you see a scar, well, no one else. A lot of us don't, I should say. Dr. Mulligan also testified that he charged $17,500 on a lien basis, which means he gets paid only if plaintiff wins or if plaintiff pays him. But plaintiff testified under counsel's own examination on Monday that she couldn't afford a $15,000 or $20,000 plastic surgery bill. So we know she's not going to pay Dr. Mulligan. Dr. Mulligan knows that he is going to get paid, if at all, the $17,500 only if his testimony helps plaintiff recover money in this case. That is a big incentive, and because of that risk, he testified he added a 20% premium to his bill. That's plaintiff's side of the scale, which keeps disappearing. And it pales in comparison to Cardi's side. So, of course, Cardi's evidence starts with Cardi's testimony, which will appear shortly. Thank you. Cardi is one of the 3 eyewitnesses who directly contradict plaintiff's story about what happened that day. Cardi testified that in February 2018 she was pregnant. You may remember in this trial that plaintiff's counsel asked Cardi, "Why does that matter? You're pregnant." No one knows, but why does that matter? Well, it did matter, and Cardi testified, and you should consider, and I hope you remember Cardi's response. She felt her privacy was completely being violated and that her medical issues are not anyone's business. Quote, especially something that is so sacred as your pregnancy. It's yours. No one knew she was pregnant. Her parents didn't know. And she shows up for an appointment, and this woman is photographing, filming her, and then getting belligerent. Now, I mentioned that Cardi testified her parents didn't know she was pregnant at the time, and it's common sense that no daughter would want their parent to find out that she's pregnant by social media. This was a secret. There were special arrangements made so that she could see an obstetrician while in LA on a Saturday. Now, Cardi testified that she came to Los Angeles for the NBA All-Stars weekend, and concerned she made an appointment with the obstetrician for Saturday afternoon. I'll get to the photograph in a minute. Cardi testified that she got off the elevator to go to the doctor's office at about 1:30 on the 5th floor of that building, and plaintiff started filming and photographing her. Cardi objected, and plaintiff apologized at first, saying, "Oh, my bad," which is effectively an admission that she was doing what Cardi thought she was doing. Cardi testified that plaintiff wouldn't stop and just kept following her with her camera, with her phone out. Cardi testified that she was very concerned and nervous and confused by plaintiff's conduct. That is understandable. Cardi testified that she was concerned about her unborn child. Cardi referred to plaintiff as security heavy. She's a large woman. She's almost twice the size of Cardi. Cardi's pregnant, early in her pregnancy, and this person comes up to her in black boots and starts yelling at her. Cardi was concerned about her, and scared, frankly, about what she might do to her unborn baby. Cardi also testified she was confused. Why is this going on? Why is a security guard doing this? Why is she filming me? Why is she following me? Cardi also told plaintiff specifically that plaintiff was invading her privacy. But when Cardi told plaintiff to leave her alone, plaintiff went berserk. She yelled, it was plaintiff's phone. Plaintiff said, "That's my phone. This is my building. You can't tell me what to do." That's what Cardi testified, and it's consistent with what Tierra Malcolm, and Dr. Finke testified. But plaintiff advanced on Cardi, screaming and yelling and forcing Cardi backwards down to the hall to a corner, coming chest to chest with Cardi, yelling at Cardi about how, this is her building. She can do whatever she wants. Now, hearing the yelling, the doctor's receptionist, Tierra Malcolm, and then the doctor intervened and tried to get plaintiffs to stop and leave. We'll talk about that in a few minutes. In the meantime, Cardi testified that she and plaintiff yelled and used curse words, but neither struck the other. Cardi did not strike plaintiff. Plaintiff tried but did not strike Cardi. Cardi testified.
I don't want to interrupt. We're coming up on a break. If there's a logical place to stop.
I can stop there if you want to,
Okay.
Alex.
All right. Why don't we stop there, folks? We're going to resume back at 1:30. In the meantime, please not discuss the case with anyone, including other jurors. Don't form any opinions or do any research. We'll see you at 1:30.
So they're gonna take a lunch break in the middle of this dark. Y'all couldn't thug it out. Cardi over there about to go to sleep. We couldn't thug this out till the end and get done. Then let them go on lunch and deliberate over sandwiches. No. Now we got a whole hour just to chit chat. Thank you, Brown Southern Girl, for the super chat. She said, I think Cardi B is over this side show. Sensible Creation said, for the goal, you deserve it. Thank you so much. Hold on 1 second. I got to grab my phone because I'm still technically working. I got that still going. Sorry about that. Okay, so what are we thinking? Nicole Wilson Smith said, I think the judge is trying to make sure they deliberate until tomorrow. He did say, like, well, they're 3 hours behind us too, so it's only 1:30. So really, if they come back, well, it's 12:30. It's 12:30 there. So if they come back at 1:30, they do have what, about 4 hours? So I don't know how long he gave them for closing. Did anybody hear that? Because I probably just wasn't paying any attention. Did anybody hear how long they had for closing? I don't know. I know the plaintiff took an hour. I don't know how long he's been on there. Miss Jam said, now we get on YouTube to see what people are saying. Well, here it is. $0 for past and $0 for future. Is there anybody on here that feels like Miss Ellis should get something for either her injury, her pain and suffering, punitive damages? Anybody? Okay, I'll let you guys marinate on this picture. Based on what we have saw, this is the evidence. This is Exhibit A. That is the evidence. Is there anyone who believes that Cardi should have to pay? Now, somebody said something about hold on. Thank you, Nathaniel, for the Cash App. I appreciate you. Somebody said something about, let me look at the question, see if I can find it. You said, is it a cheek or a nose? Oh, that's what it was. Somebody said something about her being a celebrity and that some people feel like, why don't you just pay up? There's going to come a point in time of which some celebrities are just not going to pay you. Yeah, it's money that they would like to keep in their pocket. I'm sure they would like to spend it on something better than this. However, you cannot set a precedent that, oh, all you got to do is be in the vicinity of Cardi B or anybody else, and whether I'm wrong or she's wrong, I can still sue. So they're going to use some people as examples. Unfortunately, I think this guy, for the attorney, I think he just got a case of which Cardi was like, nah, I'll eat up what I've done, but that's it. Like I'll take that on the chin what I've done, but I'm just not gonna let people talk about we got into a straight up brawl and I'll scratch your face up and all of that. And you get millions of dollars. So apparently now that amount, because Cardi said that, people are looking at like, girl, 24 million, cut it out. But I'm sure Cardi didn't get that amount. She ain't pull it out of her hat. It may have been a demand letter or something that was sent, but she probably did get that number from somewhere. And now it looks ridiculous. I mean, it just sounds and it looks ridiculous. So, what her attorney did do, which he needed to do, was to explain that he's not asking for millions. But it wouldn't shock me if there was a demand letter or something that happened before the lawsuit and they asked for millions. And Cardi was like, I'm not giving you nothing. And then a lawsuit ensued, because usually you try to get it before litigation, because you are going to get some celebrities that don't need the bad publicity. And if this was Cardi's first pregnancy, this was around with her first album, and like she said, she didn't want anybody to know because she was just get signed and her career was just taking off. And then to get pregnant for, and her get pregnant and you're just starting your career. Remember what happened with Jess Hilarious over there at the Breakfast Club? People were saying the same thing about her. When you immediately get pregnant, when you get a job, it's a risk for some women. So I think because of the persona she still wanted to give and all of that, she didn't want people to know that she was pregnant. She kept it a secret. M. Torres said, I wish the attorney wouldn't have called Miss Ellis a bully, overstating her authority or something like that. I agree, but I'm not sure if the jurors will like it. I think she did come across as a bully. The reason why I think they said that, and of course I'm speculating, I'm not in Cardi's attorney's head, but I believe that came up because what they started out doing, Miss Ellis's attorney, was to try to make Cardi look bad. Remember, the whole security heavy was to try to antagonize Cardi when she was on the stand, to basically say it. What do you think about her? What do you think? She fat? What do you like, trying to get her to body shame her in front of the jury? Was trying to take it to just show she has this history, because the attorney wanted to enter in all of the stuff people were talking about when they were like, oh, Cardi did it based on past acts. He wanted that stuff to come in. That's why he slipped in the gang affiliation. He wanted all of that to come in, so they were dang near, even though there'll be an instruction, don't base your decision off of an emotion. Don't base your decision off of the past. All of that will be told. But how can you really get it out of your head? Same thing with the Diddy trial, if you guys followed it with me. Same concept. We gonna keep playing this video of him beating her over and over again to the point where we forget what the actual charges are. So we want to get him on something because of that video. So that's the same. You can try to say you have another reason and motive for trying to enter in other acts, but that was probably the rationale, to try to say if she did it before, she'll do it again. And the judge did not allow it because it's more prejudicial than probative. It has nothing to do with the facts of this case. You're just basically trying to say that anytime somebody comes, because Cardi has this alleged history of whooping on somebody before, then she'll probably do exactly what they said that she did. And that's not fair. That's going to get you hit with a whole lot of lawsuits if that becomes what's precedent when it comes to her or anybody else. So the judge did not allow that information. And I think in their mind, it hurt their case. I think he almost banked on it. He wanted Cardi to show that she is a person that will cuss you out, call you racial slurs, and she ain't black, to try to be offensive. Like that would be offensive if we know she called a black woman a ninja, and she, even though she's Afro-Caribbean, because people don't know the difference between race, ethnicity, and nationality. That's what I'm learning on this internet. And so the attorney was trying to use that in order to incite and get emotion out of the jury. That's what it looked like they were trying to do to me. So to say that he didn't say she was, they needed to say it ain't Cardi this time. She told this my building. You beating your chest like you the police and you really have the arresting powers or something. No, you are a security guard. And yes, you're supposed to keep keep it safe, lock some doors, check some cameras, whatever you're supposed to do. And if an emergency really happens, you're supposed to call the police. And honestly, why they said, well, she didn't countersue, like, what would Cardi do that for? Then she back in litigation. She's not trying to just be in litigation for no reason. You said rent a clock. Kelly said exactly. The facts of this case don't prove an assault. If anything, I can't get the image out of my head of the security guard cornering her. That's what, but the security guard accused her of unlawful imprisonment. It must have got dropped or something already, because that definitely was not really brought up in this trial, except it was the other way around is the way it looked. Of course, Miss Ellis can say, well, it was all this stuff that happened before the doctor got out there or before the receptionist got out there. They can bank on that. But the thing is, why did you follow her in the first place? Why didn't you just turn around, get on your elevator? Because they were on the 5th floor. You got other floors you can be patrolling. So it sounded like because she didn't do what you wanted her to do, you were going to let her know, I got authority to put you out. If that don't sound like a bully, I don't know what a bully, because you don't have that authority. If that doctor told her, I told Cardi to come into the office, or the receptionist told Cardi to come into the office, she's invited on those premises. You don't have the right to put her out. She is an invitee on those premises. She had an appointment. When the situation happened, the doctor didn't say, I'm canceling your appointment, leave. The doctor said, come in here for your appointment. So the whole argument about she told her to leave and she defied authority doesn't even make sense, because that's not your building. You're contracted to help to protect the building, protect the people that's in there, and not fanning out because you see Cardi. And this doctor testified that he sees celebrity clients often. So I heard some people say, which I thought the plaintiff was going to try to say, that, oh, this doctor just testified like that because he want to keep his clients. No, he wants to get more clients. I don't think that that's the case. I think that, like I said before, that is a bad reputation. If Cardi would have came and told what she says happened to people, that could have affected his business. It's not about getting more clients, because he was getting celebrity clients before her. But it was about, what if the bad taste in her mouth, if she got pissed off enough where she went to the internet, talked about her experience in that building when she went to go see her, when she went to go see him and for an emergency, that she said she felt funny and she was having a medical emergency, being 4 months pregnant, and this is what she was greeted with. That's a bad taste on the doctor. Yeah, he's gonna go complain. But I heard some people that were commentating was like, oh, we all know it's biased or whatever because they are fans. Well, heck, the girl that's suing her is a fan too. What does that mean? So anyway, Annette said, I call bull crap. Michelle said, should a complaint be filed against him? Joe said, hey, good to see you. Toria said, when they were trying to promote her and get her started, she was on different things, just really getting started. Let me see. I know I went back on the, somebody gave. Minx the Cutie, thank you so much for the memberships. I appreciate that. Nicole said, Imani accused Cardi for all the charges that could have been charged toward towards herself by Cardi or the receptionist. What if the receptionist said, that receptionist said, no, I just put some little alcohol on it. I got scratched. It was bleeding. I just put a little alcohol on it and I put on a Band-Aid. I put on a Band-Aid and kept it moving. The security guard lawyer could have called Cardi's bodyguard. He didn't. That's true. I think he mentioned that about them not calling Cardi's bodyguard, but I mean, he was downstairs and he came in after the fact. But I think they were trying to say there was some interaction, or Cardi allegedly apologized to the plaintiff saying, I'm sorry about what happened. I think that came out, if I recall correctly. So that's why they brought him up. But Cardi testified he wasn't there. She called him while she was in the doctor's office. But I mean, the receptionist also, what did she say? Miss Ellis also said she never called the receptionist. And the receptionist was like, oh yeah, she called me. And the doctor said 2 other attorneys came there. Not this attorney, but probably the one she tried to contact before this attorney got on board. So Jam said, but reception said the scratch was from Imani, which was key. Yes, the receptionist said that because she was in her face. But the bottom line of trying to say they didn't come till after the fact, it doesn't really help them, because even after the fact, you should have saw a scratch. Nobody saw anything. So that's a problem. And then I guess her mom and grandmother, they didn't see her. They don't even remember when they saw the scratch. So I don't know how far after it, if it was 2018, 2019, 2020, 20. They don't know the exact time. Then you had the plastic surgeon, who this was one of the juror questions. They said, well, can you tell how old this scratch is? And he was like, no, there's no way to tell. So he doesn't even know when it happened. He couldn't even. He's not a causation. He's a plastic surgeon. So he's not a causation expert. So it's like he doesn't know. He can say it looks like a scratch, but scratch from what? And a scratch from who? So. Kelly said, and she never put in her report that she had a scratch on her cheek. Yeah, and then the mom, now what the grandma did say is that when asked about the scratch, she said it was on her face. I mean, her face would include her cheek. So the grandma did say that, if they want to use that as in rebuttal. Pam, do you think Cardi's attorneys tell her to formally announce her new pregnancy over the weekend? I know that's tugging on the juror's empathy. Did she announce her pregnancy over the weekend? Child, I missed that. Thank you for the super chat. I didn't know she announced her pregnancy over the weekend. I thought we were all just speculating based on the wobble in the clothes, the clothing choice. I didn't know that. I didn't know that. Ty said she didn't announce it. Child, where she announced it at? And maybe we can pull it up. Oh, she didn't. Offset said she was pregnant. Child, I don't know. Okay, they saying she didn't announce it. Okay. All right. All right. She was speaking in past tense. So I don't know. I mean, we can all speculate. Like, that's why she's so sleepy. But yeah. Yeah, I hadn't heard that. So they're saying there wasn't any announcement. So thank you, Susan, for the Cash App. I appreciate it. They said there wasn't any announcement. So Tyrone said she found out how fast they got rid of her Monday morning. Who you talking about? She was just going off on a reporter outside a few minutes ago for this. What reporter? I can't believe that all those people living in California. Oh, here she goes. She's struggling.
You guys today? Any thoughts on her character at this point? Now that you had some time to really look at it.
Cardi, ¿qué esperas hoy? ¿Qué esperas hoy, Cardi? Mira, le puedes firmar a Cardi, chicos. Cardi, are you pregnant? Are you having twins, Cardi? Please.
You can't ask a woman that, right, Cardi?
So I guess that's it. She told them to go to when they asked was she pregnant. She does look she does look cute. You said it's a different one? Nicole said, Pam, I think Imani Ellis should get a payout enough for Tylenol extra strength for her pain. Cocoa butter and aloe vera gel for her scratch. That's all she get. Nothing else. That's kind of messed up. That's pretty stingy, don't you think? I'm trying to say if it's anything exciting, from this. Yeah, if you're just coming in, we are on lunch break from the Cardi B trial, so just go ahead and hit that like button for me. All right? Hit that like button. Subscribe to the channel. I'm trying to work too at the same time. Resilient said he was shady mentioning the security heavy comment. Well, he talking about her feminine health too, so. You still so future damages, you're not the only one lost. But so what they do is you'll get a mortality table on every year. Of course, there is a life expectancy. So if you're talking about future damages, if I'm hurt now, then I may be hurt in the future. And what is that worth? Because I can't come back. Once you get a verdict, that is what it is. Once you settle a case, it is what it is. It usually takes care of futures, those ailments unknown. She found out 3 years from now, she got some nerve damage or something. Like, you have to incorporate and try to get as much as you can while you're there. So the future damages, if she's 35, then they'll say, well, our life expectancy is probably about 50 more years or something. And so they may calculate, well, that she may have lost $100 per day, or she may $50 every month or whatever. So they do it for the future damages of what she will endure. The only thing they really know for sure is allegedly, I guess she's supposed to get some type of more surgery for the scratches. And so that was worth $15,000. So those are the only exact amounts that they had, were the medical bills she paid before, which is $17,500, and then the $5,000 that she had outstanding. And she didn't go till 2022. So you didn't even see this person to get any type of surgery for this scar until after your lawsuit was filed. Just saying. You didn't go to an emergency room. You didn't file a police report or a police complaint. You didn't do any of that.
And that's really the one that he worked on. Now, the issue in this case is, well, before I go to that, is the photograph that you saw, okay, which is in evidence. There's a
I'm like, y'all don't want to hear him again.
Which is a 2 centimeter scar. The photograph, because of the skin color, it does not show well in photos.
Because of the skin color, he said, this does not show well in photos. Again, that is the scar. Basically, because she's black, it does not show very well, is what they're alleging. These are the nails that's being alleged the scratch originated from. That attorney is dragging it, call it microneedling plastic surgery. Well, that's what the surgeon said. That's what the surgeon. So what they're saying is there's a financial benefit. It's a 3-minute procedure. You charge $17,500. Now, what is true is anything that has to do with drawing blood, you have to be like a medical doctor to do it, because that's the thing they have with like acupuncture. Even though because of the invasiveness of it. So anything considered invasive, they'll say that it's some type more of a surgical procedure. So if you're not a medical doctor, then you have to do it under supervision of someone that is, or whatever. But having surgery, saying you're written out of suite, you got to have a sterilization to put it in the surgery position or naming it as a surgery. That basically means you can charge about $11,000 more. So they're saying that you did this out of financial gain. You have every reason to try to say, oh, this is a surgical procedure, something that requires surgery. Now, the interesting part is obviously plastic surgery is a choice. So it wasn't anything that was like, you get rods and pins in your leg because you were in an accident is necessary. People that get fusions on their neck because they've broken bones in their neck, or back surgery. It's not one of those. It's more of cosmetic for the scarring that they are alleging. So it's a cosmetic. So when you have permanent scarring, you can try to allege that this is a permanent scar you have to live with for the rest of your life, and try to get damages based on that permanent scarring as well. Erica, thank you for the super chat. She said Erica Ellis needs to go to church and ask for forgiveness. Minx the Cutie said, if anything, the receptionist could have sued since she visibly had a scratch. I think nobody took this as a lot. I mean, even the doctor, Cardi's doctor, temporary doctor, because it wasn't her regular treating physician, she just had an emergency, said that he couldn't believe it. And I looked at his face. I think he was being honest. He was like, I just felt like it was ridiculous when I found out she was trying to sue somebody. Like, I thought it was crazy because that's not what happened. That is what that doctor said. So, no, it's not over, Cedar Elm. They are on lunch. So we're just chit-chatting a little bit. So go ahead and grab your sandwich and your drink, because they're not coming back till 4:30 our time. So I guess I could remove that, huh? Tyrone said she's gonna need tissue for the tears they're about to come for having to pay this crazy lawyer and a plastic surgeon. So I'm gonna assume, without looking at their retainer, that this was taken on contingency basis, meaning that he gets paid if they win. If she can't pay $17,000, then she probably cannot pay an hourly wage for a lawyer. Just assuming. Just saw the pen incident, nothing major, but Cardi do need some work on controlling her temper. What is the pen incident? We got another incident here. She put up a video saying she wasn't pregnant, but she does look pregnant. Where's that video at? She could just be, eating a little bit of snacks after 8. We've all done it. Will she have to pay Cardi's lawyer? So that would be statutory. It's not mandatory that you have to pay somebody else's lawyers. For the most part, we go by the American rule, which is you pay your own lawyers and we pay our own lawyers. But there are statutes of which they do allow, depending on what the claims are, sometimes they will allow attorney fees to be paid. Will that be the case as it pertains to the Cardi B trial? I don't know. It's me said yes, because she's been in a couple of accidents, so any future problems she may have could be from the accident. Yeah. Could be. They definitely gave an alternative. Who is going to close after lunch? So Cedar Elm, the plaintiff, Miss Ellis's attorney, has already done their closing, and Cardi's attorney started their closing. However, they're going to finish after lunch. So that should be in the next 25 minutes. Thank you for the super chat. You said, if the situation was more than a verbal, I am sure Cardi's security would have been asked to come to the doctor's office and not just wait by the door. Valid point. If someone is just coming after you for money, they should have to pay the lawyers. Unfortunately, anybody can file a lawsuit, and oftentimes, I know in federal court, when you're pro se, the court is more scrutiny on it. But for the most part, when lawyers file it, I think there's deference, because we all of our court rules of professional responsibility, we're not supposed to affix our name to documents that are not grounded in law and fact. You may not know all the facts, but you need to have enough reasonable investigation of which your facts rely. So yes, if you just randomly somebody come to you with this crazy story, like it seems like what's happening a lot with these Diddy cases, you need to do your own investigations. And again, the court doesn't require that if later on we find out there's a whole video showing that your client was the aggressor, the court is not going to penalize you for that as a lawyer. But if you find out that they're the aggressor and you still pursue it, then you may be sanctioned of attorney fees. So paying attorney fees, for the most part, are usually considered sanctioned. So for instance, you file a motion to dismiss. I really don't have any arguments. You've proven everything. And I tell you, I don't want to respond to this. And this is what it is. I gave you this information. That's what those Rule 11 sanctions come in federal court, that we see a lot of on these Diddy cases and these cases that are filed like by Ariel Mitchell and Blackburn and all of that. Because when these cases were filed, the attorney said, look, here's the information that this is impossible. These are the dates. It's an impossibility happening here. And they decide to pursue it. So now you have to unreasonably spend time when you could have saved your client money. So yes, your client is going to want attorney fees for that. So there are certain incidents of which where that happens, but generally speaking, you're supposed to pay your own fees. So Bayou Brew, I said, how are you bold enough to take pictures and videos of someone in the doctor's office and not use the same phone to take pics of your injuries? So she's alleging she was not taking pictures or videos. But again, because there's no phone, we can't verify it. So that's kind of how I was looking at it more so. But I get it. She's saying allegedly, I guess there were pictures taken of the injuries. But from my perspective, I said, oh, that's real convenient because the data, you cannot get rid of data. So if you had to turn over your phone, like what's going on with Milagro right now, where there were deleted messages, which we all do. It didn't mean it has to be nefarious. A lot of people delete messages after conversations. I keep all my texts because I might need some evidence. But there are some people that delete it. But if you get a forensic expert to go into your phone, they can tell what was deleted, what was not deleted. They can tell all of that. And you may be able to get information. It sounds like in this case, especially since it was older as well, they weren't able to get text messages, pictures, and all of that directly from the carrier. And it's interesting because apparently there's no iCloud or anything. I don't know what type of phone it was, but a lot of stuff is backed up, but apparently there's no backup. So I think they more so wanted the phone for purposes to show that you were videoing, that the evidence would show there was some video, you did take pictures, because they used the records to show that she was on the phone around that time. But I think they wanted to use it for that. And again, they could have used it since she testified, oh, the pictures were in there, so they could have, used that for that purpose as well. But the phone is gone. They don't have it anymore. So I got about 7 phones with everything still in them, just in case. I still have, you know how you had cameras back in the day that were disposable? I still have about 20 of those I need to go take to somebody's pharmacy and go to the photos part, which they probably don't even, they probably like, ma'am, get with the program. We do things on USB. But I still got those cameras and don't want to get rid of them just in case I have something that's, may bring me some money someday or something, some historical picture. What is my thoughts on plaintiff closing? What do you think? What do you think was BS? I didn't like the closing. I thought that they were going to tie it all together, but the style is interesting. Cardi's attorney did what basically everybody does. You thank the jurors for their time and their attentiveness, and you appreciate them taking out their time, because some have the opposite opinion when it comes to that. They don't. I've heard some people say, don't do that, that's a waste of your time that you have in front of a juror. But for the most part, I think the most general consensus is that you thank the jury. And then he was very methodical with it. He did his chart. He said basically she starts at 0 and she got to bring it up to 51%. So let's go witness by witness, evidence by evidence, and that's what they're doing. They said they're going to show this. They're not able to show this. I told you in the beginning to hold them to their proofs of what they say they're going to show. If you did not get that from them, then this goes toward whether you can believe what they say, because they weren't able to show you what they said they were going to prove. That's what I told you in opening statement. Oftentimes you pay attention to what they say that they're going to prove, because you wrap it back up in the end. They told you that you were going to see information about this. They told you it would be someone proving this. They didn't show that. Did you see it? I didn't see it. So I think that Cardi's attorney is doing a better job of presenting why they have not met their burden. I don't think they did a great job in meeting their burden on the plaintiff side, because the only real evidence that you have is obviously your client who has something to gain, and you have her relatives. Then it was this whole fiasco of, I guess, an alternate something. I don't know who made this allegation, but there was an alternate who allegedly talked to the grandma of Miss Ellis. So it's just, then it was the plaintiff was doing, entering information, saying information, even though what we say as attorneys is not evidence, you have to rely on the evidence, what was shown, but you're playing dirty by in trying to talk about evidence that the court has already ruled on and said it was inadmissible, making claims that were not proven, or stating things as if they are facts that were not proven in the case. It was just a lot going on. So I can't say that it was a good closing, because it just sounds like you're reeking of desperation. Now, what I do like, as I said before, is Cardi did mention 24 million, and we were all looking like, girl, if you don't cut it out. So him saying we're not asking for millions, we just want this, and this. But at most, let's just assume, like I said, there was a scratch. I don't think the scratch was purposeful, which is what it is when that's an intent. I think if there was scratching, just like any spitting, I think that it was not on purpose. I don't think it was intentional. And I think that's all they really pulled out, was perhaps an accident may have occurred, but she accidentally scratched the receptionist. Should she be suing her? I mean, what did they say he wanted? So he's saying he wants the $17,500 medical that was paid for that micro needling. He also wants $15,000 because she's supposed to go back and get more, and some more for the scar removal, and everything else is really up to them. So pain and suffering, he said, we're not asking for millions. We're asking for, even if you say it's worth $250,000 for the pain and suffering, that's fine. So it's really up to them. But no, they're not. They clarified that they are not asking for $24 million. Do you think the judge will give him a fine or admonish the plaintiff's attorney? I think that they are going to do a show cause hearing, because there was a lot of behavior that was happening that should not have been. So you can buy a micro needling thingy on Amazon for less than $15. Well, sis, you might want to go ahead and buy it and get you a sterile location and see if you can get a doctor to supervise you and make $17,000, because apparently that's where it's at. Okay, they said he testified all the time as an expert. He got great credentials, and he can charge $17,500 for what you said costs $15. Okay, that's right. You said the lawyer just, that's what he there for. All you can do in civil is get money. So you calling it begging, what he supposed to be doing? What is he supposed to be doing? I am unique. But I think that was another problem that I really had during his direct examination when he was putting on his case in chief, was that he focused a lot on the money aspect of it. And to me, you don't even get there until you prove that you deserve the money. So he always put that much emphasis on it. So it makes it seem like that's what it's about. And I get it. He probably wants to recoup this money back. He spent money. He's paying the plastic surgeon, got paid $2,000 an hour to be at trial. So he's coming out of his pocket. That's what you do when you take cases on contingency. So I'm sure that he is. Money might be on his mind. He wants something. He's like, I'm humble. I come before you as humbly as I know how. 200 is good, okay? 200. Can we get 200 out of this? So I don't know. Hold on, I gotta send something over. Hold on, y'all. I gotta email something real quick. You guys keep talking amongst yourselves, okay? Let's see. What motion in limine is this? Oh, okay. And sorry, guys, had to send an email. Yes, it's 1:16:17. Yes, we got about 12 more minutes. I didn't think we were gonna make it. We didn't chit-chatted our way through. I just didn't want to start a whole nother live. It's too much work. So you said Cardi looked sleepy. Through the whole thing, she was like, and they kept the camera in her face like this. Probably like that lady had it. They had it right in her face like this. She was like, then she was like, she's rolling out her album now. So she's busy. How long has it been since she had an album? She said she's immediately going on tour. So she's rolling out an album, so she's tired. And she got them babies at home. I mean, Pam, do you think Cardi should give something? The plaintiff's attorney in me would say, yeah, but I mean, in this case, no. I didn't see any reasoning to give anything. But it's always interesting because I'm sure Cardi's attorneys are not cheap. And she probably paid them way more than what she would have to pay this lady. So this situation might have been so triggering to her that she was like, I'd rather give them $2 million than give you $1. Now, what is interesting, thank you forever, T. I appreciate the super chat. What is interesting is, I forgot what I was going to say because of the super chat. It'll come to me. I don't know, really be. Some saying she pregnant, some saying she not. She didn't announce it. They said she might have said she wasn't pregnant. I don't know. But listen, the way she went off on that security guard allegedly, child, it ain't none of our business. We gonna mind our business until Cardi B says she wants to let us know that she is pregnant. You know how she do her rollouts and the maternity shoots when she 9 months. Cardi let everybody know she pregnant and she had a baby the next week. That's how long she can keep her pregnancies. So I'm gonna mind my business because I'm not trying to get cussed out by Cardi B. You know what? She just threw a pin at a reporter. Y'all better leave Cardi alone. Cardi's attorneys stay busy. Yes, Riri. Y'all been waiting on an album for Riri for how long? Riri, like, I don't care what y'all talking about. I'm not giving you no albums. And I'm about to have a baby every year to commemorate every year I don't give you an album. Um, I'm trying to see what you guys are talking about. And Cardi is definitely that girl to pay an attorney $2 million to not give that girl. Listen, Cardi said, I would rather give this 2 million to them to give you 50. And the way she was like, even when she was on the stand, she was like, you know, she was there. She know what she did. She know what she said. Ask her. She was there. Like, they were really talking on Zoom. That's how she was on the stand. Like, she right there in box number 3. Just hit the unmute and tell her to come on. Tell her to come on the camera. That's how she was talking when she was at that table. Like, she was there. I mean, she just sounded believable to me. Now, other people are like, she used the ninja word over and over again. And even if she did say it, I'm not understanding why that increases your damages, because it's not outrageous, or it doesn't qualify as intentional infliction of emotional distress by any stretch of the imagination. So, but that's why I said a lot of the stuff I think he was trying to get in was for people to be like, oh yeah, Cardi did everything they said that she did because this is what she does. She at no point in time can contain herself. Because that's really what you're saying. She has no self-control and discipline is what they're trying to allege. So I'm glad that the case was streamed. Like I told you all in the beginning, that kept telling me about what Cardi always does. I'm like, would you want to be judged from a bad moment you had on every situation so people could just come and take your money? No. So don't do that to her just because she's a celebrity and you feel like she has it. It's still her money. If she want to take it and throw it all at the strip club and not give it to you, that's on her. And heck, she might do it. She might go to the strip club on camera, give away $1 million before she get this girl $2.50. Life with Lois said, I don't feel like she proved her case. I think it's too much. Yeah, 51%. I just don't see her meeting that burden. Even her testimony evolved over time. So you got, like they pointed out, you have the surgeon saying she was basically scratched like this with the middle finger scarring her face, which is what allegedly caused this scar. So this is what they're saying. The middle finger scarred the face. Then you have the surgeon who is supposed to be the plastic surgeon. This is what they're saying. But then they show a video deposition of Miss Ellis where she's saying she basically jabbed at her. So the way it happened, causation doesn't even match is what they show. You're saying it was more of a jab when you were instructed on video, which is smart to do a video deposition. Some people, oftentimes we just do depositions. We'll do them without the video for the most part. But people with money, they do all of them with the videos and they have the transcript. So the video depicted her describing, they asked her, show me how you saying she did it. So when that movement didn't correspond with the movement of this plastic surgeon who is supposed to tell you how it allegedly happened, that's a problem. So, listen, everybody don't want to work for their couple of dollars, Q Lady D. They don't. Mimi said, if this was legit, yeah, but Stevie Wonder can see this for what it is. I think they both, giving her the benefit of the doubt that there was some contact and some scratches. I just don't think it was on purpose. I think Cardi will probably punch you in the face before she just try to cat fight you and scratch you. I don't really see that. I think they both were cussing each other out, going all off. And it sounds like Cardi went in and followed directions and went into the office, and they had to get Miss Ellis to go ahead and get on the elevator because she wasn't moving to even get on the elevator. She's still going all off and trying to, she hit me, and all of that. I guess that she was yelling and she didn't even want to get on the elevator. She scared, whatever she said. Well, Cardi is not incarcerated. She's sitting at the table dozing off. Okay. So it's no need to free her. She is out. This is not a criminal case. This is a civil case. Okay. Talking about free Cardi. Cardi ain't even, what's she about to be free from? Y'all are funny to me. You said Offset. Listen, let's just assume Cardi is pregnant. Y'all know by law that's really technically Offset's baby because she's still married. That's how it is in most states. If you get prego, I don't know, maybe California switch it up because there'd be a lot of shenanigans or wherever they live at. I don't know. But I know in Michigan, in most states, in many states, if you get pregnant while you are outside, you can be separated for 20 years and don't get a divorce. But if you get pregnant by someone while you are while you are married, then it is considered a baby of the marriage. And I know how it was in Michigan. It's a little different. Now they've evolved it a little bit more, but it used to be that the guy, even if he wants to be the dad, he doesn't have standing to challenge paternity. So that means he can't go to court and say, this is my baby and I'm swabbing the cheek and all of that. It has to be the mother of the child, or it has to be the husband who's saying, this ain't my kid. I ain't been with this chick in I don't know how long, or I've been with her and I ain't know she was cheating on me, or whatever it is. And that's how you get into court. But there were a lot of people, a lot of men that were trying to be in their kid's life, but they didn't have standing in court to challenge it, because sometimes you're going to get an honorary husband who like, yeah, bro, this me right here, this my baby. And then you can't even do nothing because you were in there spreading it low and spreading it wide and messing up families. And that's how the government looks at it. I was on Law Review. I did a whole article on that. That was actually what my article was on. That law and trying to change it. Because I was like, well, that's crazy. That's kind of crazy. But yeah. Deb, this would be your baby. What are you talking about? I said, what? If I go frolicking around the city of Detroit, you are the daddy. whether you like it or not. Don't come here with no foolishness.
Listen.
Don't come here with no
Listen,
foolishness. You the daddy no matter what, okay?
I'm gonna say one thing.
If I have
I'm gonna say one thing.
a night of fun and I end up pregnant with somebody, you the daddy. Period. No conversations. No need for us to even talk.
Can I look the internet in the eyes and give them my response? For real, I'm gonna use the statement.
They'll say that baby's happy.
Hold on. Can I look them in the eyes and give them a statement that I didn't make up? It's used by the United States Postal Service, which is federal.
Oh God, here you go.
Huh?
Look, he in the back of the house, but he heard that. You ain't heard nothing else. I ain't really been on this internet, but he heard that. He said, you a damn lie.
Because everything else was somebody else's BS. This BS would be something that personally I'd have to deal with.
Toria said, Deb, you the daddy.
Huh?
Lexi, the law nurse, said, Deb said, hold up.
Beautiful people, listen here.
Here you go.
Hold on. This statement is a statement by the United States Postal Service. If, for whatever reason, my wife lost her mind and she allowed her mind to be taken and frolicked and tried to come back with another man's seed, I'm going to wait till she tell me. I'm going to get her the tissues, all of that. And I'm going to say, return to sender. Whoever sent you home with this, I'm going to return you to them. Ain't no way in the whole hell and under God's good heaven. I want you to look at me. This, Keep that over there. Keep that over there. Listen here. Baby, it was good while it lasted. Listen, it was good. Where do you want me to send your items? Because on this same day, you are getting the hell up out of here.
You gonna put me and my baby on?
No, I'm a return to sender.
Whoever you take me back to my daddy house?
No. Your daddy didn't make that. Whoever you made that with, that's who I'm a return to.
What if I don't know who it is?
Oh, that's worse. Oh hell. It was only one whore in the Bible.
Val said, Marvin said you the pappy.
Hey Val, you supposed to be my sister, Val. Stop that. And tell Marvin stop with that BS.
Sorry, you said this is better than the try.
Val, if that's the case, I'm gonna drop her off at y'all's house, and y'all can help her take care of it. I'm not feeding nothing.
Child, if I have a baby this well, we got some problems. I have a baby at this age. Listen, that's a problem.
If she have a baby at this, I'm laughing. Because I know she's gonna go cuckoo for Cocoa Puffs. She's gonna be off her. Listen, intellects, I'm telling y'all, I'm gonna record it when she try to tell me, Deb, I got something to tell you. After she tell me, I'm gonna say, hold on, repeat it again. I'm gonna make my own meme, like how with homeboy was sucker. I'm gonna make my own little clip because she's gonna be cuckoo for Cocoa.
Okay, that's enough. It was a hypothetical. All right, relax. Calm down, okay? You acting like Cardi and Miss Ellis in this case.
No, ain't
just
no
relax.
See how women do the hypothetical?
Relax.
See that?
He on a hype. Tell him to relax.
Listen, I'm from the East.
He act like I just came with a pregnancy test.
I'm from the East Coast. All right, East Coast. We don't do that. You know what I'm saying? Me and Danielle, we're gonna be like, peace out.
Okay, give me a kiss. Yep. You don't even want to kiss me on a hypothetical. Dang, you think Go, Deb, go. Okay, go.
Hypothetical. Just in case. Father, in the name of Jesus.
Get him. away from me.
Block these hypothetical demons. In the name of Jesus. Amen.
Mika said Dad made a whole life thing. Dad, I was talking about Cardi's situation, and then it turned on me somehow. I'm old as dirt. At least get somebody with a vibrant uterus. Having these hypotheticals.
Let's talk about another hypothetical.
Okay, come on, y'all come back with this now. It's 4:30. I need y'all to come back. Oh my God. That was funny. He took this thing real serious. My God, today. He said they were about to unplug the whole internet, right? He said y'all got my sugar up. You ready for the trial? Well, they gotta finish their closing, Jules. How you gonna say I'm ready for them to hand it over to the jury? Oh my gosh. Ned said that was very entertaining. Welcome to our life. Welcome. I was just giving a hypothetical. That was it. I was talking about Cardi B, and that's probably why Offset's saying the things that he's saying, because technically that would be his baby. Now again, they can go and denounce all of that stuff as long as she does it and he does it, but you have to have standing in the court to do that, and usually an outside person does not have standing to contest it. That's all. Right. He came out here like, that ain't even nothing to even like pretend. Like, I'm like, you saying that like I'm in my 20s or my 30s or something. Like, and that's a possibility. That better not be in the realm of possibility. First of all, somebody would have to go find me, because I'll probably be walking down the street in a daze with a robe on or something. So that would be the first situation. I was almost walking in the day when I had Danielle in my 40s. I couldn't believe it. I said, wait, what? Huh? They was like, you hear the heartbeat? I'm like, the what? I just sat there with tears in my eyes. Dev ain't say nothing. We walked in the car in silence like it was the Green Mile. We got in the car. We ain't talked. We just sat there. Came home. He went one way. I went the other way. And I just sat there. I just sat there and I stared at the wall. I said I was almost free. And I just stared. I said, I can't believe I'm this old and I got this little, you know how they give you if you had a baby, they give you the little plastic bag with all the little samples of everything. I walked in there for a regular annual exam and walked out with one of those baggies and a prescription for prenatal vitamins. I just couldn't believe my life. I said, God, why? Why? Why me? So no, if that happened now, child, y'all really have to call that hotline. You have to call the hotline on me, because I know. Granny DeGray said, Dad, buy you a cold drink. My brother. Thank you. Woo. I hope you guys enjoyed that entertainment. We are waiting on the other half of the closing for Cardi B's side of the V in the assault case brought by Miss Ellis. They were supposed to be back at 4:30 and they're not back yet. Okay. But they should be back shortly, so hold on. Right. No, my dad was like, this is what my dad said. When I told him that I was pregnant, he was like, what you do that for? He said, what you do? Then I got mad because every time I would go to the doctors, everything was AME, like AMA. So advanced maternal age. So all your paperwork, when you went for blood work, when you went for anything, they were like, issue AMA. Issue AMA. I was like, why these people keep calling me old? And I'm sitting up, oh Lord Jesus, why me? But you know, I love my baby. I wouldn't change it for the world, but it was definitely a shocker. Yep, it was a shocker. That's why I have all grown kids and Danielle. That's why. Yep, he trapped me, Nikki. He got me. He said, you ain't going nowhere. And Danielle like him more than me, so I'll really be hit. They're like two peas in the pod, inseparable. He tried to chase, he got me. I said, he got me. My dad said, why did you do that? I said, he got me. That's all I can say. I'll be back next month for another. I said, now I got to go see my doctor every month again. It's crazy. Thank you for the super sticker, Carly63. I appreciate it. I know it was a setup. I am unique. He knew what I know. I told him that too. I was like, you did this on purpose, didn't you? Once I actually started talking again after 2 days of silence, I was like, why did you do this? Huh? What were you thinking? You know, because it definitely couldn't have been my fault. Mama Keisha said I had one at 38 and my oldest was 16. So you understand my pain. Dev, you so funny. Mm-hmm. And blame it on the alcohol. Well, actually, actually, no. All right, we gotta get serious. We back in court, okay? It's enough of that. Enough of my life. You guys are depressing me, okay? Enough of my life. I got to get off of here and do second grade work, all right? When my youngest child is off at work. My youngest child before her is off at work right now. And I have to get off of here and I have to do math, English, and social studies, okay? So y'all kind of depressing me, so I'm gonna need y'all to stop, all right? But make sure you hit the like button, subscribe to the channel if you enjoyed. This was just our conversation waiting on this to come on. We're gonna get a little bit more serious, okay? Gonna get a little bit more serious. We are waiting for them to come back from the lunch break, and apparently they were really hungry because they're about 15 minutes late. So girl, I know you are playing with me. A 22, 25-year-old and a 3-year-old. Jesus. You're the real MVP. You are the real MVP. You got me beat, sis. Angel said, ain't no way. You saw the pen video? Somebody sent me the pen video. You said Ray said LA Superior Court never returns on time, like ever. Child, they over there hungry over there. They said you won't stop my lunch. What's a closing argument? I haven't been able to check any other dockets or anything today. Wasn't Trump supposed to make some announcement? What was his announcement? Anybody know? Anybody know his announcement? Cutie Pie 1230 said, I have a 31, 29, 27, 25, 18, and 11-year-old, and the baby just turned 10. Sis. Oh, I did see that Karen came home today. I did see that. That's what I said. I was almost there the last time. I was like, Lord, I don't know if I'm gonna be. I know you give your hardest battles to your strongest soldiers, but I think you might have got my name mixed up with another Pam. Because I don't think so. I don't know if I'm gonna make it through this one. But it all worked out for my good. So he does know best. I think I'm the winner, and I would with behavioral girls, 16 of them to be exact. If them daughters is a whole nother live, okay? So just that's gonna send me down a whole nother. Yes, please run these likes up. You guys, if you're just coming in, thank you all for over 1,000 that stayed with me through all of these shenanigans, waiting on them to come back from lunch. But they are supposed to come back from lunch shortly. They're supposed to have been back from lunch, but they obviously have not. And complete the closing argument for Cardi B. Subsequent to that, the jurors will take their little notes in their little purses and pens and pads, and they will go back there to the jury room where they will deliberate, and we'll see how long that takes. I don't think so, Emma Walker. I don't know. But heck, who knows what's happening in that courtroom? Every time the camera comes on, there's some extra something going on. But I mean, I think it's cool that Cardi is using the attention that she had. This is a perfect time to roll out an album because everybody's all up in her face. So every day while people are over there, I guess, trying to check to see what she's going to say and do, she's posting about her album coming out. So this would be the opportune time when you are headlines right now. Your child is out here, albeit for some BS. Listen, publicity is publicity. Is this not free publicity? She goes live. We automatically want to know if she's going to talk about She Prego or what happened in this trial. So we get on there. She starts talking about her album coming out. And bam, she has decent sales. Even though I think they said that her single, I don't know how her single did, that she did a remake or something of some song. And I don't know how well that did, but nonetheless, I think that every day she's posting about this album. It's been times she must have somebody else working her Instagram, because it's been times that I'm like, ain't she in trial? And they're posting endless stories about her pre-sales, and I guess she has an unboxing or something as well that you can go buy some products from her website. Symmetry said, yep, she was posted while she was in the car today showing the album. Yeah. TJ said the album is going to be an uphill battle. Those singles haven't been great, in my opinion. Okay. I can't say that I heard them. They probably found out the grandmother, you know what, the real pretty Patty, aka, look at everybody with the conspiracy theories on what's going on right now. What's taking so long? What's taking so long? Rappers in general haven't been selling as well as they used to. It's hard for everyone right now. Emma Walker says she has a PR team. Sensible Creation said came in at the bottom of the chart. Oh, wow. That's messed up. And she's been out for a minute. Is this like her second album? Is this her sophomore album? Because the problem is you spend so much time with your first album, and it's something that does very, very well. And a lot of sophomore albums, they have issues because you're always chasing the numbers from the first album, unless you're like Michael Jackson or something. But you always hear about the struggles of the next album, and she takes her time, apparently, with coming out with songs. So it's always an uphill battle when you go to your next album trying to chase the numbers from the first one. She kept pushing it out. Okay. 504 said, I came back and y'all done locked up Mama. No, everybody's trying to predict or guess why we have not started yet. You said get ready to cover the next trial for throwing the marker. Nobody sent that to me. You guys think the reporter is gonna try to sue Cardi? Maybe her first single just wasn't the right single or something. I don't know. I'm gonna have to check out some of her music. I was just talking to Deb about that the other day, how I used to love music, blasting it in the car. I was one of those people with the kicker in the trunk. That's annoying to me now. Now I realize how annoying I was coming down the street. I love concerts. I kept up with what was going on. And I'm like, nah, I don't even know these people. Like when I look on the Shade Room, I'm like, who is that? What do they sing? I still listen to the same music I listened to in my teenage years, in my 20s. That's it. I don't listen to anything new. Every now and then, because of TikTok, somebody will do a TikTok and it'll be something in the back. I'm like, okay, that's nice. But if it doesn't show up on TikTok or any of that, or Instagram or something, and I'm reading a post, I don't know the majority of these people. And so I I knew some of Cardi's songs that were just consistently being played everywhere. But I have not bought a complete album from anybody in decades. Like, I don't even remember. Well, let me take that back. I have a couple of clients that have albums and I download them when they come out. But other than that, but I can't tell you I really listen to them. But other than that, I don't really even listen to albums at all. So, yes. So Pam isn't saying who is NBA Youngboy? Like, I didn't know who YNW Melly was until I did the trial, and it was just something to do. Then I didn't know who Tory Lanez was until I did his trial. So anyway, I'm learning these people is because they're in trouble. That's it. Like, why am I meeting these artists of this generation based on them being in trouble? Then I'm not gonna lie, I don't want to listen to R. Kelly. I was telling them, said I feel so bad listening to R. Kelly, but I can't help but to bop my head when he comes on. Like, I can't help to start singing 1, 2. Like, it just comes out, and I'm trying to not like it. Like, I'm trying to throw it away out of my system, and I just cannot do it. I don't know. Just a dilemma. We're just chit-chatting until they actually come onto this camera. I just can't. It's so, like, it comes. I'm not saying I just search for it, but I'm saying if I just so happen to be in the car and it plays, I find myself just bopping my head and not changing the channel. I know. I don't know. Just a dilemma. Just explaining and expressing some of my dilemmas with music. Emma Walker says, step in the name of love. I don't know. Yeah, I don't buy it. Like, no, I don't purposefully. But that's a whole nother conversation. I know. But I also compare, and that's comparison is the thief of joy. But I also compare current artists to my time. And I got to stop doing that. Like, this is a whole nother generation. In our generation, our parents were like, that ain't no real music. You don't know nothing about that. You don't know nothing like that. You don't know nothing about that. Like, I used to represent Martha Reeves from the Vandellas, and she's still into, she wants you to be able to read the music. She loves live bands. She wants live vocals because that's what they did. You know, that's what you did at Motown. So that's their real music. They don't really like all of that. You going in the studios and your different vocals and you trying to get voiceovers and voice boxes and all of that. So they'll say some of our music isn't as good. So I get it. Like, every generation goes through that. But I just can't get with a lot of the music from this generation. Val said Kelly is trash. You said half on the baby, but you were singing it though, wasn't you? Because it was catchy. Angela said, no, I think people need to mind their own business. All I listen to right now is Beyonce, Kendrick, Jay-Z, some Meg, and Cardi in Old School. That's from Elite Leo. Val, now you're doing too much. Now, the lyrics and stuff was catchy. He was using metaphors and similes. The last 10 years of music has been trash. See, but they don't think so. They think just it's more about the beats. Like TikTok is the new wave of music. So as long as you can dance to it, do routines to it, you almost have to create your music to fit where you can have some type of routine or dance to it. All right. People don't care about the word. That's why you got little kids doing this Chris Brown thing. I'm like, they like, then they doing this. I'm like, hello, about the eating part. Relax. Because they not even listening to the lyrics or the nastiness of the lyrics. It's just all about a routine. I'm like, okay, all right, I get it. Okay, I'm getting all that. Okay, all right. Then they like, I'm like, whoa, wait a minute. But people are doing it with their kids because everything is about the beats. They're not even really paying attention to the lyrics. And the same thing I think with our generation, we sang the lyrics, but we didn't really know the depth of what we were singing. We hadn't been through half the stuff that was going on. Now we can listen to it, and I think we more relate to a lot of the R&B. We're like, I went through that too. He did that too. I know. Like it makes more sense to us now. We've lived life now, so we get it. We've been through some of the things that people are talking about now. You said the old people were nasty. Vintage said, if you can't make music that makes me envision a video, it ain't good to me. It's interesting. No, you can't use the Plan incident from today and rebuttal. Because they couldn't even use incidents that happened before. You can't use any outside or bad acts. You said check out October London. I will do that. You said, did she decide to settle? Something must be going on in the judge's chambers. I don't know. Singing As We Lay by Shirley Murdoch didn't have no business. I know. Now I pay attention to lyrics. We were all sitting up there acting like, but that's like Superwoman. I think Karen White was talking about it and how young she was when she sang it. And you got Monica talking about just one of them days. You're like, girl, you was like 14. What are you talking about? You said October London is great. Okay, I'm gonna have to check them out. Check it out. Toria said there were a whole bunch of rumors Trump's in bad health. Yeah, I've heard that, but I don't know. He was supposed to do, they showed the agenda of him today, and he was supposed to come on at 2:00 and talk about something, but we don't know what it is. All right, I'm gonna have to check it out. Child, I'm sorry, I gotta sit up here and do improv because these people taking all day. I apologize in advance. Used to sing Salt and Pepper. Did you guys hear what's going on with Salt and Pepper? So you guys know Salt and Pepper filed a lawsuit because they're trying to get the 35-year revision back of copyright, of their intellectual property from the music from back then. Well, allegedly and apparently they were signed to a producer, and the producer was the one signed to the record company. So that's why the record company was like, you ain't got no business suing us. You don't have standing because we don't owe you nothing. Our relationship was with the producer. So they're trying to get their money back. So they over there fighting, I think, in the Southern District of New York. Then you got people that always say Salt and Pepper does Spinderella wrong. So now the original Spinderella, she's come out and giving her 2.5 cents. And she basically said, why are they suing and they don't own nothing? So yeah, it's a mess. But this is the time that people that we grew up with, they're getting their intellectual properties back, because you have an automatic reversion after 35 years. And so 2 years prior to, I think it's between 2 and 10 years before you give notice that you're going to get you want your stuff back when that time expires to get your masters back. So that's why you see a lot of posts from people from my area that are saying, I got my stuff back, got my property back. So you got people like Salt and Pepper that have been begging and they ain't get nothing back. And their argument is you don't own it. So it's gonna be very interesting. Okay, I did see. Oh boy, I knew I should have stuck up long term. Hold on. Hold on one second, y'all. Sorry.
Cardi also testified that she is in fact left-handed, and we've talked already about how that undercuts Dr. Monica's theory that a right-handed person caused the claimed scar. Cardi testified that she didn't have any 3-inch nails at the time of this incident in February of 2018. She also testified that she was in Los Angeles. She lives back east, and she was in Los Angeles for the NBA All-Stars weekend in 2018. And we put into evidence a photograph of Cardi to prove that her fingernails were an inch or less. It's a photograph that she testified was taken at the NBA All-Star week. And you heard counsel earlier say that Cardi testified that photograph was taken on the same day of the alleged incident, on February 24th. That's absolutely untrue. She did not testify to that. If you are unclear, the record can be read back to you, but I expect that you were here and heard Cardi testify that she was here for a week or so and kept the same fingernails this entire time, and that includes February 24th. The assertion by counsel that she testified to something she did not, in fact, testify to is something that Your Honor, that the judge had already indicated is something you should disregard. Now, she testified that the nails she was wearing while she was in Los Angeles were coffin square and not pointy. That was a new one on me. Apparently, coffin square means shape and square and can't cut anything. She also confirmed and testified that the rhinestone images were flat. They were not pointy and they had no sharp edges. Apparently, you can get little rhinestones either as little decals on fingerprints or as rhinestones themselves. I'm not like Dr. Finke and fingernail expert, so I won't talk about that. But the point is, rhinestones can appear on a fingernail, a decorated fingernail, either as three-dimensional or as flat, which of course flat can't cut anything. And she testified, as did Dr. Finke, well, excuse me, I misspoke. She testified that they were flat. Dr. Finke, counsel had said, testified that they were sharp. He actually testified he didn't know whether they were sharp or flat. It is very important, actually, also that while plaintiff's testimony about what happened is uncorroborated, she called no witnesses who were actually there. Cardi actually did have 2 witnesses. And we'll get back to that. I do want to mention something that plaintiff's counsel raised, which is there's testimony from Cardi that as plaintiff advanced towards her swearing and pushing her back, that their chests touched. And counsel told you that that's an assault right there, that client wins. Well, there's a couple of problems with that. Just touching chests like that is not an assault. And if it is an assault, it's an assault by plaintiff on Cardi. Cardi was being pushed back. That's the testimony from all both of the witnesses and Cardi herself. But I should mention, just in case you want to know, there is an instruction in the jury instructions that deals with the defense of self-defense. Counsel said that that is inapplicable here because Cardi denies that she touched anyone or had to act in self-defense, or that she cut plaintiff. The point he's overlooking is that is up to you. We've heard the evidence. We think it's overwhelming that Cardi did not touch a plaintiff at any point in time and did not touch this magic appearing, disappearing scar. But we have to be careful as lawyers. So we've included a self-defense, a defense of self-defense instruction, which means that if you were to find that Cardi did touch plaintiff, or that somehow a chest-to-chest caused by plaintiff is an assault by Cardi, which we dispute strongly, there is an instruction that the judge has given you that self-defense applies if a person reasonably believes that another person was going to harm her or him, and the person uses only the amount of force reasonably necessary for protection. I think there can be no doubt that Cardi was faced with someone bigger than her who was trying to hurt her. We know that from both Cardi's testimony, Tiara's testimony, Tiara Malcolm, and I believe also Dr. Finke. But let's talk about Ms. Malcolm. Tiara Malcolm, we called her as a witness, so we'll add her there. And she is one of the 4 people who were in the hallway, and she testified as an eyewitness, and she has no axe to grind. She's not a friend of plaintiff. She's not a friend of Cardi. She doesn't work for Cardi. They never met before. And so, again, she's an independent third-party witness. She testified that she was Dr. Finke's receptionist and expecting Cardi for a secret appointment. As a receptionist, she was near the front door. That's why she got out first before Dr. Finke, whose office was in the back. She testified it was a Saturday and all the other offices in the building were closed. And they closed early because, quote, they didn't want anyone there when Cardi arrived. When Ms. Malcolm, she testified that when she heard yelling, she immediately ran out. She's near the door. There's nothing she really could have missed once the yelling started. A defense counsel has argued that, again, that she wasn't there in the beginning, but we know from her testimony that she was near the door, immediately ran out when she heard yelling. Now we have a visual rendering based on plaintiff's own photograph of the hallway outside the doctor's office and based on the testimony and Cardi of Ms. Malcolm. This shows how far, you see the elevator bank and you see the doors that are depicted in the photograph that plaintiff showed you, plaintiff's counsel showed you. And where did they end up? They ended up in that corner. That's how far this demonstrates, based on the testimony and evidence in this case, how far plaintiff forced Cardi B backwards and into the corner that Tiara Malcolm saw her when Tiara opened the door into the hallway. Ms. Malcolm specifically testified that when she opened the door, she saw that plaintiff had Cardi against the corner. Ms. Malcolm testified that she said, "What are you doing? You're at work. Go back to your post." And that the plaintiff just refused. She was going after Cardi. She was yelling, screaming. Ms. Malcolm testified that she got between them, with Cardi behind her and with Ms. Malcolm facing plaintiff. The evidence is that at that point, Ms. Malcolm testified that plaintiff was swinging at Cardi, who was behind Ms. Malcolm. That's what she testified to. Now, Ms. Malcolm didn't realize at first that she was hit. She went after Dr. Finke came out and tried to deal with plaintiff. Ms. Malcolm took Cardi into the office, and someone else at the office, this is what she testified, what Ms. Malcolm testified to, someone else at the office said, "What happened to your head?" That's when she found out. In all the brouhaha, she did not realize with Cardi behind her and plaintiff in front of her swinging away, Ms. Malcolm did not realize that she had been hit. Now, counsel told you in his opening statement that Ms. Malcolm didn't know she was hit. She knew she was hit. She went back to the office and she saw the scratch on her own head. Counsel has argued
Your
that
Honor, I would object to him referring to counsel. We can talk about facts, not counsel.
plaintiff's counsel has argued to you that that Ms. Malcolm didn't know who hit her. Okay, and he dwelled on that a lot in his cross-examination of Ms. Malcolm, and with all the things flying, and with all of plaintiff's hands flying in the air, what Ms. Malcolm explained is her back was to Cardi. Ms. Malcolm specifically testified she did not see Cardi's hands go in front of her, go by Ms. Malcolm's head, but she did see plaintiff flailing away trying to get to Cardi. That's why she concludes that it was plaintiff who hit her. And it only makes sense. Cardi was behind Ms. Malcolm, and Ms. Malcolm was hit in the forehead, face to face with plaintiff. Again, I apologize for the language, but it's important that you hear this. Ms. Malcolm also heard plaintiff, who was almost double the size of Cardi, expressly threatened in no uncertain terms to harm Cardi. Quote, "I will F your shit up." That's what Tiara Malcolm testified to. She heard plaintiff threaten Cardi. That's an express threat. If anyone was being assaulted by threats of immediate offensive contact, it was Cardi who was being assaulted by plaintiff. Ms. Malcolm testified that while Cardi was behind her and Ms. Malcolm was face to face with plaintiff, Ms. Malcolm did not see any scratches or cuts on plaintiff's face, any blood on plaintiff's face, any injury at all on plaintiff's face, or any spit or spittle on plaintiff's face. Ms. Malcolm also testified that Dr. Finke came out of the office into the hallway and tried to get plaintiff to stop and leave. Ms. Malcolm then got Cardi into the doctor's office. She testified that throughout this, plaintiff had her phone in her hand. I want to repeat that, since she testified here that she was using earphones. We've got another witness who says plaintiff was standing there, flailing away with her phone in her hand. Now, Ms. Malcolm also testified, and I know this gets a little bit repetitive, but it's important you remember this testimony and you take it into account when you deliberate. Ms. Malcolm also testified that Cardi did not hit plaintiff, that Cardi did not cut plaintiff with her fingernails, that Cardi did not use the N-word. Cardi and Ms. Malcolm testified with Cardi behind her, almost touching her back. She did not see or feel Cardi swing at plaintiff. They didn't touch each other, although counsel asked what about chest to chest, and Ms. Malcolm testified, which seems truthfully, when plaintiff had Cardi in a corner, Malcolm could not tell if their chests were touching. That's because she's behind them. She's coming out of the office door. Ms. Malcolm also testified that a few months later, plaintiff asked Ms. Malcolm to help her go after Cardi. Now, if you remember, counsel for plaintiff elicited testimony from plaintiff that she never really intended to sue Cardi. She never intended to go after Cardi. But that's not what Ms. Malcolm says. Ms. Plaintiff was trying to elicit witnesses to support a claim against Cardi. And Ms. Malcolm said, "Thank you, but no thank you." And she did that because she felt that plaintiff was at fault and, quote, "she handled everything unprofessionally," close quote. Now, we also called Dr. Finke. He too was there the day of the incident, and he too has no axe to grind. He is not her regular doctor and never has been. He saw her that one occasion on February 24, 2018, when Cardi was here for work for the NDA All-Star Weekend and was concerned. She was pregnant, she wanted to see an obstetrician, and an appointment was made. He is a completely disinterested third-party witness with no axe to grind. Now, Dr. Finke, like Cardi and like Tiara Malcolm, testified that plaintiff, well, first of all, he testified his office was at the back of the suite. He heard yelling and he immediately ran to the front. Okay, so he gets there very quickly too. And he just has a little more distance to cover. And he testified, like Cardi and like Ms. Malcolm that plaintiff had her cell phone in her hand. He saw plaintiff trying to hit Cardi. He saw poor Ms. Malcolm in the middle. And by the way, do you remember in the opening counsel for plaintiff said, well, Ms. Malcolm threw herself into the fight. If she gets hit, she gets hit. That's what happens when you try to help. I mean, really? I mean, she's a doctor's receptionist. She sees a patient coming there for a secret appointment, a pregnant patient. She tries to stop a security guard who's got the patient cornered in the hallway. And that's like, she asked for it? Is that really the answer? Dr. Finke also testified that Ms. Ellis had scratched plaintiff had scratched Malcolm's head. If you remember, the evidence is that Tiara Malcolm did not realize she was scratched until someone else in the office, the doctor's office, pointed it out. And also that Dr. Finke, once he got plaintiff to leave, which he refused to do, that he went back into the office. So he had a chance to see her at that point. That supports his testimony that he saw the scratch on Malcolm, not on plaintiff. Dr. Finke also testified that he told plaintiff, do your job, you're a security guard. But plaintiff kept yelling and she refused to leave. Kept yelling at them, kept yelling at Cardi. Now, while Dr. Finke tried to get plaintiff to leave, he was face to face with her. He testified they were within a foot of each other. And he testified he saw no cuts or scratches to plaintiff's face. He saw no blood on her face. Despite the fact that he testified that a cut on one's face bleeds more than a cut on any part of the body. This woman claims that she was cut in that encounter, but no one has testified that she had blood in her face. In fact, she testified she doesn't know if she had blood in her face from a scratch that supposedly ruined her life. He also testified that he saw no spit or spittle on her. He also heard, he was there when plaintiff expressly threatened harm to Cardi by saying, I will F your S up. Now, Finke testified that Cardi did not spit on plaintiff or anyone else, did not take a swing at plaintiff, did not hit plaintiff, did not cut or scratch plaintiff, did not threaten to get plaintiff fired, did not use the N-word, and did not call plaintiff fat or poor. Dr. Finke also testified that once Cardi was safe in his office, he examined her in an examining room, and she did not have 3-inch fingernails. Now, in an interesting term, that was a surprise to me as well. He said he actually notices his patient's fingernails because it's a way of calming them down. It's a way of lightening the mood in the examination. So he's seen a lot of fingernails. And he looked at hers, and hers were not 3 inches. There were allegations, and you've heard little bits of it, that Cardi supposedly got plaintiff fired. Actually, Dr. Finke said it was him. He told his administrator, his practice administrator, that this was outrageous, and based on the conduct he saw, plaintiff had to go. Cardi did not make a complaint. Cardi is not the reason that plaintiff got fired. Plaintiff is the reason that plaintiff got fired. Our evidence also included plaintiff's February 24, 2018 incident report. Plaintiff was asked in discovery, and we read some of that to you, which are formal written requests for documents or information, sworn under oath by plaintiff in this case. We asked for documents relating to the incident, emails relating to the incident. She never produced her incident report. We had to subpoena it from Ally. That's how we got it. We didn't get it from her. She claimed it didn't exist. Once again, common sense. There's something wrong there. We had to serve a subpoena on Ally, who produced a copy of the incident report, and we relied on that incident report because of plaintiff's inconsistencies and admissions. Now, it contains a lot of her accusations, and we believe that evidence is clear that they are false, but it also includes some interesting statements by plaintiff, and this is 2 days after the February 24, 2018 incident. Plaintiff, who testified, if you remember, that incident reports are very important. And she testified, and in the incident report, she told her supervisor that that Cardi had scratched plaintiff's nose. Not cheek, nose. 2 days after the incident, when she's blaming all of this on Cardi, which I think it's safe to assume that she was improperly doing so, given all the evidence we've heard. Plaintiff told her supervisor 2 days later, Cardi's, with 3-inch nails, the evidence is against that as well, scratched plaintiff's nose. Nothing about a cheek. And again, a nose is not a cheek. They're different. This raises 2 points, really. Plaintiff's first statement that Cardi scratched her nose is directly contrary to plaintiff's sworn testimony here that Cardi scratched her cheek. Okay. So if we accept that, then the statement that she put in her report is clearly false. Because she's now saying, and she's been saying for a couple of years, no, it wasn't my nose, it was my cheek. Second, plaintiff admits that her nose was not scratched. So this is a very important document because it confirms that she made false statements about the incident. At a minimum, she made the false statement that Cardi had scratched her nose. This statement, this incident report that she said is very important, also apologized to Allied and the building owner, quote, for behaving the way I did. Okay? Why would she apologize to them if she was attacked? Why is it something that she would apologize for? Again, common sense. She was apologizing because of the way she was behaving. She's apologizing to them for her professional misconduct. She's apologizing to them for attacking a medical patient who's trying to go in for a medical exam.
You wrap up about 10 minutes.
Can I have a little bit of extra time since council got extra time?
I don't know that you did, but please try to wrap up.
Okay. I'm going to do this a little bit faster, and I apologize. We also called Nicole McKenzie. Nicole McKenzie is an interesting person because she's a psychologist, a workers' comp psychologist, and plaintiff called her too. It's baffling why he did, because all of her testimony only helped Cardi. First of all, no one called Dr. McKenzie as a psych witness. There were no psych witness questions. We called her because what plaintiff told Dr. McKenzie in April of 2018, just 2 months later, is directly contrary to what she's been saying. Ms. McKenna testified that let me rephrase this because I'm trying to cut some of this out. Ms. McKenzie, who you may remember, testified in this case that everything that she was saying was what plaintiff had told her. And she testified that when Dr. McKenzie did the evaluation, plaintiff made no mention of being scratched, cut, or even touched by Cardi. She actually said Cardi, quote, almost, close quote, touched her. Almost is not touching. Plaintiff has offered no explanation as to why she told Dr. McKenzie Cardi almost touched her. Ms. McKenzie also testified that in doing her evaluation, she would note any physical symptoms. And she confirmed that plaintiff identified no physical symptoms 2 months after she supposedly got cut in this incident. In response to one or more of the jurors' questions, the judge elicited the response from Dr. McKenzie that it was her standard practice that even if someone came to her just for a psychological examination, that she would also note any physical symptoms that were reported, and also that if she saw the patient and saw, they've got a cut, or scrape or bruise or whatever, she'd note that as well in the report. And none of that was noted because none of it existed. We also asked plaintiff about her Kaiser medical records. At this point, I'll just mention that she testified and admitted that out of 161 pages of medical records over 2 years, there was no mention of any cuts, scratches, anxiety, PTSD, or anything else. Counsel noted that we called Dr. Rosenberg, who is a lifetime board-certified medical doctor who specializes in psychiatry. He has impeccable credentials and decades of experience. He, by the way, does not work on a lien basis. He does not work, we paid him, he does not work on a lien basis, so he doesn't have the same incentive that Dr. Mulligan has to spin his story. Dr. Rosenberg wasn't asked to diagnose any psychiatric conditions that plaintiff has. So in this report, he specifically said no diagnosis. But he did come to conclusions, okay, which is different than a diagnosis. And what he did was he had a 6-hour recorded interview of her, and he had her take a gold standard test of 335 questions. And what he learned from the test was that she claimed symptoms, different symptoms, and so many symptoms that only 2 out of 1 billion people in the world have those symptoms. He also testified that there were inconsistencies with her story. We talked about the McKenzie analysis, in fact, that the plaintiff didn't mention any problems or physical injuries to Dr. McKenzie. We talked about the initial incident report, which says a scratch on the nose, but not a scratch on the face. So with all these different inconsistencies, that went into his analysis as well. Now, he also considered that in the Kaiser medical records, there's no indication of any of those injuries. And counsel, for some reason, focuses on vaginal discharge to say, well, if you're going for that, you're not going to mention a cut or scrape. But that's not what Dr. Rosenberg testified to. He testified that in April 2022, plaintiff went into Kaiser for a complete history and physical, and plaintiff specifically in questioning denied any kind of mental health issues, including anxiety or sleep problems. In April 2023, she went in again, and for hand pain that time, and she was specifically asked, Dr. Rosenberg said that's what Kaiser does. They ask you about everything, just noted in the records. And she was asked, but again, reported no emotional problems and did not request mental health assistance. I should also mention this claim about PTSD. Dr. Rosenberg testified that you can't, quote unquote, an argument or an unpleasant interpersonal interaction isn't a trauma and can't lead to PTSD. The claim of PTSD is frankly an offense to those people who actually have it. She had a 45-second argument. She was fired. That is not what gives you post-traumatic stress syndrome. And we know that because we've heard it from a licensed psychiatrist who did all those tests and interviewed her for 6 hours. I should mention that Dr. Mulligan is a plastic surgeon. He's not a psychiatrist. So Dr. Mulligan couldn't and didn't rebut Dr. Rosenberg's conclusion that plaintiff is feigning. Counsel said, well, why didn't the defendants call a plastic surgeon expert? Because we don't see a scar. To call someone to say, can you examine this person? Do they have a scar? You can look at the photograph. Why would we call a plastic surgeon? Conversely, though, they want to prove that plaintiff had psychological injuries. Why didn't they call a psychiatrist? Let's talk a little bit about plaintiff's shifting stories. First of all, plaintiff alleges that Cardi spit on her. It's a disgusting allegation, of course, and I hate to even mention it. And everyone else says it didn't happen. But for her part, plaintiff also hasn't gotten her story straight. If you remember, last Monday she testified in her February 26, 2018 incident report. Plaintiff told her supervisor that Cardi spit on her before people came out of the doctor's office. But at her deposition, Plaintiff testified that Cardi spit on her after they came out. She can't get her story straight. That's that simple. Counsel has referred to spittle. And so what he's basically backed off of is initially it was a terrible spitting at her client. Now it's, well, maybe it was an accidental spittle, say it, don't spray it kind of thing from junior high school. There's no evidence that happened, but it's also not an assault. It's also, when you look at the jury instructions, you'll see that an assault requires intentional conduct, intentional battery. Accidentally, spraying a little bit of spittle when you're arguing, that is not an assault, and there's no evidence that it even happened.
That's what I said.
Plaintiff also is strikingly inconsistent regarding her claim that Cardi touched her. We'll go through this quickly. We talked about in the February 26, 2018 incident report, supposedly Cardi scratched plaintiff's nose. In April of 2018, plaintiff told Dr. McKenzie that Cardi almost touched her. In sworn responses in discovery in this case, plaintiff stated under oath that Cardi viciously beat plaintiff about the head, face, and body. You haven't heard that, in this trial. No one said that occurred. In her deposition, plaintiff stated under oath that Cardi struck her on her nose and cheek, and plaintiff acted out Cardi jabbing plaintiff's face with an outstretched index finger, which is directly contrary to, and you saw that videotape of that, it's directly contrary to what Dr. Mulligan testified he thought happened.
Objection, Your Honor. We're just going by over an hour now.
What's your objection?
That we agreed to 1 hour.
Okay, counsel, what's your record?
Can I have 3 minutes?
Just wrap it up.
Okay.
I agreed to an hour.
I'm sorry, there's more to talk about, but I've got to go. Ultimately, this case comes down to what happened in a minute in a medical building hallway. And to believe plaintiff, you would have to disbelieve Cardi, you would have to disbelieve Ms. Malcolm, you would have to disbelieve Dr. Finke, and you would have to ignore all of plaintiff's contradictory statements, including whether she had a cell phone, whether she had an earpiece, all that stuff. This is not a difficult case. It is not a close case. Plaintiff has the burden of proof, and the evidence is overwhelming in Cardi's favor. Plaintiff has not met her burden of proof. And plaintiff's demand for whether it's the $24 million that was testified to at trial or the $250,000 plus that you heard today makes no sense. She suffered no injury. Cardi did not do anything wrong except try to protect her baby and get to a doctor. The court will provide you with a verdict form, and we urge you that the evidence and common sense require that you answer questions 1 to 2 as no. That will skip you over to section B. We ask that you answer question 5 no. That will skip you over to section C. We ask that you answer question 8 no, which will skip you to section D. We ask that you answer question 12 no, which is then the end of the verdict, and you can have the foreperson sign it. I also want to note that for each of these questions, as the judge previously told you, 9 people do not have to agree. You can have 9 people agree on one, a different group of 9 people on another. And we ultimately, we thank you for your time, for your consideration, and you know how we wish you roll. So, thank you.
All right.
They're
And
supposed to have
folks,
1
as we
hour.
indicated, plaintiff gets the first and last word, so time for a rebuttal case for plaintiff.
Yes, thank you, Your Honor.
Good afternoon. Thank you all for coming back. So this is the end of the road now. I said a lot of things this morning, and I basically don't want to repeat all of it.
Please don't.
The main point that I want to highlight, which what counsel has brought up, is the incident report. In the incident report, Ms. Melanie Ellis tells her supervisor that the defendant put her fingernail into her face. You will see that. Into her face and scratched her nose. She caused damage to her face. It was a physical contact. As far as the spitting, it never brought up the word spittle. I don't know what that exactly means, but in either event, Imani Ellis, who was there, who was a witness to this incident, testified that
the defendant spit on her, actually spit on her, which is an assault and a battery. Everybody gets an attorney. Everyone gets to have an attorney. Even Cardi B gets to have an attorney. All of these comments and all of these things are smoke and mirrors to hide up the truth. Bottom line is, Miss Imani Ellis, who was there, testified multiple times. She never did anything wrong in her life. She was a model citizen, good person. And she basically was doing her job as a security guard, and the defendant refused to cooperate, caused a disturbance, physically assaulted and battered her, spit on her, took a swing at her, and ultimately a couple of witnesses came after the fact, and they were not witnesses to the entire incident. The entire incident really took place between Imani Ellis and Cardi B, and it really is going to come down to who do you believe? Who do you believe? Are you going to believe Imani Ellis, who was a security guard, who did her job, who was there, who never had any problems of any kind? Or are you going to listen to somebody who's yelling and screaming, has anger management problems?
Objection, Your Honor.
Got angry on that day. There's no question. She admitted it. She said she was angry. She got angry. She attacked the plaintiff. She spit on her. She used the N-word, disrespectful. She took a swing at her. She did everything possible to cause her so much emotional anguish and try to get a reaction out of her. I don't know how it was that Imani Ellis was able to contain herself, maybe because she is so peaceful. You heard lots and lots of testimony about how she was peaceful. The issue with Dr. Mulliken, at some point I did ask Dr. Mulliken, could this scratch, could this cut have been done by someone who's left-handed or right-handed? At the end, he was very clear. You can ask the testimony to be read back to you. He said it could be done by either a right-handed person or a left-handed person, either one. And when we had Cardi B on the stand, she said she was disabled because she was pregnant, but at the end of the day, she wasn't disabled with her hands, and you can cut someone with either hand, both hands. Go to the bench press, both hands. Anything can happen with both hands. This is not somebody who was taking a swing with a basket. In baseball, you must use the correct. No, this injury could happen with the right hand or left hand, and Dr. Melka clarified that and said it could happen with either hand. Again, the evidence that needs to be brought forth needs to be proven by a preponderance of the evidence. We don't have to prove 100%. We have to prove featherweight more than 50%. In this case, we have given you so much different evidence from different people, which was Imani Ellis, her grandmother, her mother, and all of the medical records. We have a plastic surgeon who came here and explained everything. You now have the case before you where you can now determine what you feel Imani Ellis should receive to make her whole. And counsel brought up some points to try to maybe muddy the waters in a sense and try to change what really happened here. At the end of the day, we have overwhelming evidence that Imani Ellis was assaulted and battered. And we thank you for your service.
Thank you.
All right, thank you, counsel. All right, ladies and gentlemen, that concludes the presentation of evidence and argument. You're now going to be shown to the jury room. We do have a hard stop at 4:30, and by no means would I suggest that you should try and rush to be done by then. You do need to deliberate and consider all of the evidence before answering the questions on the jury form. And so if indeed it takes you longer than 4:30 today, then we will need to come back tomorrow. If you want to take a break, you can take a break, but you all need to be back together in the jury room. So please do not deliberate until all of you are back together. To the extent that we do come back tomorrow, if you want to bring snacks or anything like that, that's fine. We can discuss that a little bit later. But For now, can I have Cynthia swear in Vanessa, please?
Yes, Your Honor, the alternate, so we're gonna go to the jury.
Yeah.
Please raise your right hand. Do you solemnly swear that you will take charge of the jury and keep them together, that you will not communicate with them yourself, nor allow anyone else to communicate with them upon matters connected with the case, except on order of the court? And when they have agreed upon a verdict, you will return them into the court, so help you God?
I do.
And do you solemnly swear that you will take charge of the alternate juror and keep her apart from the jury while they deliberate on the cause until otherwise instructed by the court, so help you God?
I do.
May I please have you state your first and last name for the record?
Vanessa Garcia?
Thank you.
Vanessa?
Yes, ma'am.
I want to talk to the juror, the alternate, before she goes.
Alternate.
Grab your pens, notebooks, and personal items, and we're going to go ahead and head into that jury room. Juror number 8, juror number 7, if you want to come forward. And that alternate, if you could just stay in your seat. Thank you.
And counsel, do you see the door closed? There it is. Okay. All right, we're still on the record. Outside the presence of the jury, we do have the alternate number 1 here. Ma'am, on Wednesday, did you have any conversations with any of the witnesses? Were you sitting? Yeah, you.
Me?
Yes. Were you outside? Did you sit next to the plaintiff's grandmother on Wednesday?
The grandmother?
Correct.
I can't remember, but I did sit once, at least once.
Did you have a conversation with her?
I don't remember what I said, if I did.
Okay, so she didn't say anything.
I didn't say anything about this.
Nothing about the trial?
No.
Okay, very good.
Not at all.
Vanessa's going to excuse you to the jury room. All right. Thank you, ma'am.
I'll take your notebook.
Thank you.
And then I'll take your.
Thank you.
Dang, Toria. Thank you for the super chat.
And just for the party's information, they had some kind of conversation, may have been innocent, I just wanted to rule out an improper contact.
Thank you.
If you could please either stay close or give a cell phone number to Cynthia. Just please stay within a couple minutes in case we get any questions from the jury or if we get a verdict.
Your Honor.
Yes.
So I do want to put something on the record, but not about counsel.
Okay.
I think it's important. I think this court has a duty to handle the situation, which is what happened. During the lunch hour, Cardi B went outside and threw something at one of the news reporters. I have it on video. She's been staring at my clients, all 3 of them, trying to intimidate them. I think it's unfair, and they feel scared. They feel scared. She may do to them because of what she did to that court reporter, which I have.
That little opinion, y'all don't cut it out.
I'm sorry, to one of the news reporters. She threw
Not a reporter.
at the news reporter.
YouTuber.
Physically in front of this courthouse, on court property, outside this courtroom. So I would ask that she be admonished and be told not to handle herself in this way and not to look at my clients anymore.
All right. So the court can't make any orders for
Right.
that the court didn't witness.
I can show the court the video.
Well, I still haven't witnessed it. To the extent I think it appropriate that the parties be courteous to each other. I don't think it's appropriate for anyone to be either threatening anyone or even by way of staring at someone. People can take offense to that. So please continue that courteously with each other.
May I just add one thing?
Sure.
I've been sitting here throughout the whole trial. Plaintiff has never looked this way, so I don't know what she's talking about.
Okay.
Second, Cardi, plaintiff is halfway between Cardi and the jury box and the witness. I have never seen Cardi do anything else other than watch. Sometimes she, in response to a witness, may not.
She was asleep, child.
But I have not seen anything that plaintiff's counsel has claimed.
Okay. All right, and we do have extra security here just in case there's any kind of issue. All right, stay close. Rob.
Yes, thank you.
He petty. He brought it up because, we got to reach and do anything. We want the judge isn't making your decision, so it really don't matter. So this is the video that everybody has sent me. Let me see. Somebody just sent it to me in the text too. He said he got it on video, so he probably had them send it. We've seen this before at the Diddy trial. We've seen this before. So at Tory Lanez, I'm about to pull it up.
Hey, Cardi, you're beautiful. Thank you. Cardi, you started claiming that Offset is publicly bragging about getting you pregnant for the 4th time. Do you foresee any paternity issues with Stephon Diggs?
Stop disrespecting me. Don't disrespect me. Cardi, your court look is amazing.
You're amazing, Cardi. I still love you, even though you just threw some stuff at me.
I don't care. You're disrespectful. Don't do that. Do you see women asking those type of questions to me?
No, ma'am.
Queen.
That's a legit
Why
question.
do you feel as a man you get to ask me those type of questions? Act like you have some manners.
That's right.
And your mama taught you respect women.
That's right.
All right, Cardi.
Just Cardi. Go ahead, Bronx. You was.
And you can thank him. I'm not playing around. I was very nice. I was very kind. But you're not gonna.
Cardi, I love you. It's just a question.
Nobody's gonna get that.
Okay, I'm gonna play it again. I was getting text all through it, so let me say it again.
Hey, Cardi, you're beautiful.
Thank you.
Cardi, insiders are claiming that Offset is publicly bragging about getting you pregnant for the 4th time. Do you foresee any paternity issues with Stephon Diggs?
Stop disrespecting me. Don't disrespect me. Cardi, your court look is amazing.
You're amazing, Cardi. I still love you, even though you just threw some stuff at me.
I don't care. You're disrespectful. Don't do that. Do you see women asking those type of questions to me?
No, ma'am.
Women asking those questions to me.
That's a legit
Why
question.
do you feel as a man you get to ask me those type of questions? Act like you have some manners.
That's right.
And your mama taught you respect women.
That's right.
All right, Cardi.
Just Cardi. Go ahead, Bronx. You was.
And you can thank him. I'm not playing around. I was very nice. I was very kind. But you're not gonna.
Cardi, I love you. It's just a question.
Nobody's gonna get that.
I don't know what to say. I don't know, guys. Anyway, that is the video of her throwing a pen at him, that the attorney is acting like she picked up a brick and bust somebody in the head and they started bleeding, trying to do anything to try to. I don't know why he's trying to sway the judge, because he's not the finder of fact. The jurors are. So he wanted to put it on the record. Oh, and and then to use that to say she's intimidating her and her family. Cardi has been trying to stay awake the whole day. When did she look like she don't have energy to do anything today? We've been trying to cheer Cardi on, trying to get the message to her, girl, wake up, all day. But hey, he's trying to connect that to his client, because otherwise it doesn't make sense for you even to bring that up. Like, what does that got to do with this case? It was outside the presence of the judge. So you wanted to put it on the record. Because you got to keep your lawyers on deck, huh? Because I understand. I probably would have been a little pissed off too, to be like, it's going to be paternity issues between, like, come on now. Let's get out of people's bed. They cut it out. But I mean, she does need some. I need you to get some self-control now, Cardi. You got to get some self-control. Because they're going to be out here trying it, sis. They're going to be out here trying. This is why you have bodyguards to handle your light work. But you can't be out here throwing stuff at people because you're going to turn around and he going to oh, my eye. The pen was open and it bust me in the eye, and now I gotta go to the eye doctor, and they said I gotta get surgery. Now I had 20/20 vision. Now I'm nearsighted. Like, you don't want to put yourself through all of that. Oh, she threw the pen and it chipped my tooth. Now I gotta go get some dentistry. Don't do yourself like that, okay? Stop putting yourself in these type of situations. But she was right with her lecture. But she just needed to, keep the pen away from the lecture. That's all. But she was right to say what she said. It was disrespectful. My sister said, I'm not saying I do it, but I understand. Some of us is kind of relating to you. Just saying. I don't really talk about, I know a lot about him. I was the target at one point. So I don't bring nothing up that got to do with him, because what he did when I first came on YouTube, I didn't know who he was. And I was literally the target on thumbnails and all of that for a while. And Dev just didn't calm down from that. And that was 2 years ago or 3 years ago. Then when I was at Tory Lane's trial, he was there, and he was there with somebody I knew. So she came to introduce us, and I was like, I know him. He's the one that's been trolling me and trying to harass me on the internet, and I don't even know him. He just started tagging me and stuff because I was rising a little bit. You connect yourself to people that's kind of starting to rise on the internet. I didn't know that's what they do on YouTube. And he was like, oh, I'm so sorry. He was like, I was just trolling. I was just doing this. But I guess he wasn't expecting to ever see me face to face in real life. So I asked him about it. That was that. And it was squashed that day. I thought it was squashed that day. And then some other random things happened here and there. But so I don't even be mentioning that. So I don't want that in my chat at all, because it turns into something else. Because Dev don't like thumb thuggers like on this here internet. He take the stuff real personal. I don't take it personal because I just don't care that much. And if I see you in real life, I'll just ask you about it. And I ain't had one person I ain't asked about anything and they didn't backpedal or whatever. So he leave me alone, I can leave him alone. But this is kind of what it is when it comes to that. So I try to not even bring the name up. So that is my reasoning why I'm like, don't even put the name in my chat. But that was what it was. So he said, people only do that to celebrities. They feel like they can say whatever they want, no matter how disgusting and disrespectful it may be. And the celebrities have to take the high road. Yeah. Well, a lot of stuff is to get the reaction. And I mean, it was a viral video of him during Diddy. So I'm not giving too much. I'm not putting too much oxygen into that. So, let me see. Toria said when he attacked you, I took it personal and cursed and stupid. And I went live outside of the Tory Lane. Yeah, it was some of you guys that were around from the beginning, because I was towards the beginning, like the first 6 months I was on YouTube. And when I went live about it, he came on and he apologized. I was like, you gonna apologize because you got my whole chat pissed off. Like, people ready to ride at Don. Okay. So he did come on and he did apologize. And that was that. And from that point, I thought, like I said, that we were cool. We squashed it. But I think that maybe he wanted more of a connection, like for me to vouch that he was cool and all of that. But we're not, I never did anything to you and I didn't even know you. So yeah, I'm really you know, it's been some really jacked up. He's been on some platforms really saying some nasty things about me, been under my clothes on some of them platforms, and talked about my husband, I mean, it's been a lot. So I don't even get involved with it. When people send me stuff about anything that's connected to her, because I don't got thumb thuggers around me. I got real people that take it real personal. So in order for me to keep everybody else at bay, I can't get excited about it. Man, listen, that's how it goes, Diane. So yeah, I know all about it. Trust me. So that's why the only reason why I'm telling y'all this is because I want to explain that y'all don't got to tell me nothing about him. Because a lot of you guys are new and you don't got to explain anything about this guy because I know about him already. So Elite Leo said he does that to everyone. He'll get into it for no reason, apologize, and then find a reason to be mad at them again. Well, it keeps content. It keeps going back and forth, especially if people talk about it. Then it'll be, you'll be on you say one word and you on a thumbnail and you being tagged. So that's kind of like how it works. And somebody probably gonna tell them I said something on this video. Whatever. So and again, like I said, when I met him in person, it was unexpected. So that could happen where I'm in California, which I'm at often, and run into somebody. And it's like, I don't want that. I don't want nobody in my family specifically to think that it's a problem, because it just ain't that deep for me. I'm gonna save my stuff. Thank you, Marlo, for the Cash App. I'm going to save my energy on who I decide to have to stand before a judge for outside of actually representing somebody for something that probably got to do with my kids or something like that you done did wrong. But other than that, all that is water, under the brow. I don't even care about that stuff. Say whatever you want about me. You got it. That's how I feel. But anyway, for those that don't know, they are deliberating right now. So I don't know how long that's going to be. So we've been on here for 5 hours. So what y'all want to do, huh? We going to wait for a verdict video, or what y'all want to do? But again, there was a video that was brought up about Cardi getting mad at what somebody said about her and threw that pen at him, okay? So I'm going to play that one more time. You said I expected them to be back by now.
You're beautiful. Thank you. Cardi, insiders are claiming that Offset is publicly bragging about getting you pregnant for the 4th time. Do you foresee any paternity issues with Stephon Diggs?
Stop disrespecting me. Don't disrespect me. Your court look is amazing.
You're amazing, Cardi. I still love you, even though you just threw some stuff at me.
I don't care. You're disrespectful. Don't do that. Do you see women asking those type of questions to me?
No, ma'am.
Queen.
That's a legit
Why
question.
do you feel as a man you get to ask me those type of questions? Act like you have some manners.
That's right.
And your mama taught you respect women.
That's right. All right, Cardi.
Go ahead, Bronx. You was.
And you could thank him. I'm not playing around. I was very nice. I was very kind. But you're not gonna.
Cardi, I love you. It's just a question.
Nobody's gonna get that.
So that is Operation Pin Throw, that I'm sure be all over the internet all day. So anyway, guys, thank you so much for rocking with your girl for 5 hours. I'm about to go get something to eat, all right? I was really thinking about just letting this thing go and see if they come back with a verdict or not, so we ain't got to go through all of this. But oh, okay. I was reading your comment. But yeah, all right, y'all. I'm about to go. So hope you guys enjoyed the video. Make sure you like it. Subscribe to the channel. Welcome to all of the, I think it was about 100 new subscribers off of this video. Thank y'all so much. We'll be back if we get a verdict to talk about it and say if we say I told you so, or if we get a shocker that they say, we believe her and we're about to pay her some money. So let's see if it's going to be no cost or she's going to be found liable. We'll be back soon with the answer. Until then, though, you guys, I'll talk to you later.